RSA 376 2017 stands dismissed. However, liberty is granted to the appellant to avail appropriate remedy.
My lord, if I may most humbly pray, my lord, it was not my own fault, my lord. I may not be, but at least I may be protected to the extent the limitation is concerned, my lord.
Yes, there is observation.
There is an observation.
Yes.
Yes, my lord.
RSA 144 stands allowed.
Deeply obliged, lordship.
My lord, in item 29, I have filed additional affidavit. I may be allowed to bring on record, my lord.
Today.
May please, then let the matter come for order. Earlier it was for sent to local adalat, thereafter off listed. Next, 12 minutes.
Order.
Take it from him.
May please. On 19?
Okay.
May please, I'd like to mention one item for listing, my lord.
When?
It's admission matter. Next
When?
week, any date. Admission matter. On 19th.
Take it from him. Yeah.
May I please, your lordship, I beg to mention item number 2, lordship. Can it be fixed at 2, lordship?
Why?
There is some difficulties of my senior lordship. One relative has been demised, lordship.
I am for the writ petitioner. I've given a consent for taking up this matter at 2. I'm told that his Mukesh Sharma's relative
Yes.
expired. So,
Let it be at 2 p.m. then.
2 months.
What obliged, lordship?
May it please your lordship, lordship, I beg to mention for listing a matter for admission for next week, lordship. Covered matter, lordship.
When?
Next week, any date, lordship.
21st November,
Can it be on 1995?
19th November.
Obliging.
Lordship, I beg to mention for writ petition for next week at any court's convenient date.
On 21st.
Obliged.
May this lordship, with the consent from the petitioner, I beg to mention item number 25, my lord. I am for the respondent, my lord. I pray that matter may be open for 1 week.
Lordship, can it be on 18th or 20th? I'm the writ petitioner.
18.
18th or 20th?
On 28th, 20.
Okay.
Obliged.
Public.
As cited by learned advocates of both the parties, the matter stands adjourned to be discussed on.
On 28th, 20th November.
Okay.
Lordship, I beg to mention to writ petition for admission
When?
and eligibility for opportunity.
When do you want?
Yes.
On
When?
24th November.
Any day next week.
Is there any urgency?
Eliz-
Is there any urgency?
Yes, sir.
You could not follow.
On 20th November, 20.
Lordship, I beg to mention for listing an admission matter pertaining to pension.
Take it
Next
from.
week.
Yes.
May I
On
please, your lord-
24th
I
November.
beg to mention one pension matter. Kindly be listed on 11.
On?
11.
11.
Yes. Okay.
Lordship, we have cases. On 18th.
On 18.
Please, your lordship, with the consent from the other side, I beg to mention item number 23, lord.
Item 20.
23. Your lordship, the applicant has filed affidavit and we are going to file our objection. So 4 weeks time may be granted.
On the affair being made by Miss
B. Hazarika.
Learned Counsel appearing for
Respondent number 1 to 4.
respondent number 1 to 4. With consent from the other side, the matter is then adjourned to be listed after
4 weeks, sir.
4 weeks. And the matter also stands released from being parted.
May I please your lordship? Lordship, I beg to mention 2 writ petition and 1 contempt petition, lordship.
When?
There is urgency, lordship, because it's provincialization matters. Next week, any date,
2
lordship.
matters. One on 14th, one on 17th.
If I wait for listing of a matter for admission, lordship.
When?
On 14th, lordship, November.
Okay. 14th. Obliged, Lord.
May I please, my lord? My lord, 3 matters, 1 matter for motion, my lord, and others 2 matter for admission. may I pray for listing in the next week, my lord, any convenience day, my lord.
12,
It may not be possible.
not possible. We have already, 18, 19 and 20.
Right. Oblige, my lord.
Items from daily list for motion, item number 1.
हमारे तो नहीं. May I appeal? My lord, we have filed, my lord, additional affidavit. Their lordship will find at page 42. The enrollment, my lord, for the year 2014 to 2018 appeared in the, my lord, SSLC final exam. And also, my lord, the percentage of passed out candidates, page 42.
Mr. Mandal, whether notice was issued here.
Notice was
No-
not issued.
Notice was not issued, but in the
That
meantime,
is- that is-
we are given direction, your lordship, to obtain instruction. Instruction also received.
You,
Let the notice may issue.
you file your affidavit.
Yes, your lordship.
Now, my lord,
I-
our limited period, my lord, since my lord, DLS has not recommended our name, my lord, we have filed appeal before the, my lord, state level scrutiny committee.
Hmm.
That appeal is pending. Nothing has been done. If the, my lord, matter is disposed of directing the, my lord, SLSC to dispose of our appeal, my lord, that will suffice the case, my lord.
Yes, your lord. That can do, your lordship.
Where is that affidavit?
Also,
Appeal,
your lordship,
appeal, my lord, page 26.
instruction, I would like to place it, your lordship.
Okay,
Page 26 is the appeal.
20.
26.
List has already been given, your lordship. Uh, Remarks has given, your lordship, Habiba Khatun. Subject taught Hindi. Second page. Does not permit as per the Act 2018. New Act, your lordship, does not permit it because as per the instruction we received, it was clearly mentioned that I'd like to read it, your lordship, second line onwards. Their services for provincialization as assistant teacher in Hindi music and craft cannot be taken into consideration as the concerned district scrutiny committee, Dhubri, did not recommended their name for provincialization under the Assam Education Provincialization of Service Teacher and Reorganization of Educational Institution Act as amended in 2018. And here, your lordship, under section 2H of the Assam Education Act 2017 as amended in 2018, the service of the petitioner could not be considered for provincialization due to non-recommendation of the concerned DSC, that is District Scrutiny Committee. For the recommendation, your lordship, DSC is, your lordship, approval is needed, your lordship. And the remarks is clearly stated that does not permit as per the Act of 2018. So, your lordship, based upon that appeal, your lordship, that this case may disposed of, your lordship.
That is why we have filed appeal before the SLC. Since our name has not been recommended, my lord, by the DLSC.
Or Mr. M. U. Mandal.
Already
for the-
have no merit, your lordship,
Sorry,
in this case.
Learned counsel for the petitioner and Ms. Titas, learned dissenting counsel for the respondent, secretary to department. This petition under Article 226 of the Constitution of India, the petitioner has right for issuing direction to the respondent, more particularly respondent number 1 to provincialize the service of the petitioner by placing the recommendation of the district level committee of 2019 before the state level committee for the purpose of provincialization of service of the petitioner as assistant SRD3, comma, 80, music and 80 craft at Nasser Mandal Memorial High Madrasa, District Dhubri. Mr. Mandal learned counsel for the petitioner is submits that the petitioner has been serving as assistant teacher in which subject?
My lord, page 26, lordship will find. We have given the, my lord, Hindi teacher, music teacher and craft teacher. Page 26.
Hindi teacher, music teacher and craft
Craft.
teacher respectively at Nasser Mandal Memorial High Madrasa, Dhubri with effect from 5/8 to 2001.
My lord.
Mr. Mandal further submits that the petitioner is eligible and qualified at the time of their appointment under the provision of the Act and Rule 10. By recommendation of the District Scrutiny Committee dated 6/2/2019, the teaching and non-teaching staff of the madrasa have been recommended for provincialization as tutor, but the name of the petitioner has not been recommended. And being aggrieved, the petitioner has preferred an appeal before the state level committee on 17/12/2021 and since then. No, but the same failed to evoke any response from the respondent authority. And as such, Mr. Mondal submits that his petition may be disposed of by directing the state level committee to dispose of the representation of the petitioner dated 17/12/2021.
Yes, my
Leader,
lord.
Bernard Johnson, counsel for the respondent in Education Department, Secondary Education Department, amidst that he has received instruction. And as per said instruction, the said instruction, provincialization of service of the petitioner is not permissible under the Act of 2018. However, she submits that she has no objection if this rate petition is disposed of by directing the respondent number 1,
My lord, 2 and 3, my lord.
One,
respondent number 2 and 3.
Commissioner Secretary one.
Dated 17/12/2021 by passing one speaking order. Accordingly, taking note of the submission of learned counsel for the party,
2, 3.
this court is inclined to dispose
Apni
of this petition by directing the respondent number 2 and 3 to dispose of the appeal filed by the petitioner on 17/12/2021 and by passing one speaking order, and the aforementioned exercise has to be carried out within a period of 3 months from the date of receipt of certificate copy of this order. The petitioner shall obtain a certificate copy of this order and place the same before the respondent number 2 and 3
Respondent
within
two.
a period of 1 week from today. In terms of a please, dispose of.
Deep lord. My lord, can it be, my lord, 2 months, my lord?
Deeply obliged.
Okay, 2 months.
Obliged.
I know in this case, last occasion also, earlier 3 times and last occasion also they have took time to obtain the instruction regarding the completion of the process. In view of the letter that is been issued by the Secretary Education Department, my lord, that is on, my lord, this is on 25/9/2025, by which they have specifically stated they have received the copy sent back by the Judicial Department and they now under the process to comply this, my lord, the entire process of compassionate appointment. Then like,
In this regard, there is one development, the development has occurred, my lord. After examining the views of Judicial Department, now file has been moved to the Finance Department for necessary concurrence, my lord. This is.
But how much time you will take to complete the work?
My lord,
Dharma?
on receipt of SIU approval from the Finance Department,
SIU approval is already received, my lord. It is their communication, my lord. SIU, my lord, Lordship will see, my lord, this is my last document. Yes, my lord, this is 48 page number. In earlier occasion also, this is the last communication.
Page number 40?
48, my lord. In earlier occasion also, my lord, the last occasion, lordship, that is enough, my lord, to see this last annex 6 at page 48. The content of the letter is inviting the reference to the subject cited above that I am desired by the government of Hyde letter numbers as mentioned above. Under the reference number 1, I have honor
No,
to submit here with the
sir,
copy of the SUI.
Mr. Mohanto,
It is already copied.
the proposal is forwarded in the SIU format.
Yes, madam. It is already. Madam.
The concurrence has not yet been received. Heard Mr. Mohanto, learned counsel for the petitioner, the youth learned counsel for the respondent. Higher Education Department,
Secondary education.
Secondary Education Department. Mr. Sarma, learned something counsel for the Secondary Education Department has produced one letter of Joint Secretary to the Government of Assam dated 4/11/2025, and on the basis of the said letter, Mr. Sarma submits that after examining the views of the Judicial Department, the Department of School Education has moved the file to the Finance Certificate SIU Department for necessary concurrence on 27/10/2025. And once the SIU approval is received from the Finance Department, the Department of School Education will take further necessary action. When Mr. Sharma submits that he may be granted 2 weeks.
Within 2 weeks, my lord.
2 weeks time.
It is already enough
then
time
the
has been gone, my
environment
lord.
accordingly, taking note of the submission of Mr. Sharma, learned counsel, standing counsel for the respondent in Secretary Department, and also of Mr. Mohanto, learned counsel for the petitioner. It is provided that Mr. Sharma shall apprise this court after 2 weeks about the up-to-date status of the said proposal. List the matter after
26th November.
Master blade.
Mr. Sharma, you ask them to expedite the matter.
Yes, ma'am.
Made little losses.
The affidavit has not yet been received after some time.
My lord.
Items for admission. Item number 3.
May I please, Your Lordship? May I please, Your Lordship?
Mr. Sharma, you have filed your affidavit here? When?
Monday, Lordship. I received the copy on Monday, last day before yesterday.
But
Is it on
not
record?
yet been checked with the record.
Is it on record, Lordship?
Sorry.
Check
Relevant to the.
Record, no, recorded নাই
Or record.
কৰিছিলে মোক কপি দিছে Monday.
check
So let it be on Monday then.
Yes.
Monday. Art Ms. Sharma, learned counsel for the petitioner, and Mr. U. Sharma, learned assistant counsel for the respondent in the Secretary Department. So Sharma submits that he has filed his affidavit in opposition on 4th of November 2025. But it appears from the record that the same has not yet been checked with the record. Accordingly, it is provided that Justice shall raise the matter on Monday, along with the affidavit in opposition filed by the respondent in Secretary Education Department.
from 10 to 11.
Obliged.
Item numbers 4 to 8.
My lord, look at the order dated 9/9/2025, my lord. Annexure 6 ৰ ওপৰত affidavit দিব দিছিল মানে চিঠি এখন আছে নাই 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 মই আপোনাক
Yes, so whether detailed affidavit is filed by the
My lord,
respondent
an
or
affidavit
not.
has been filed, my lord. An
Filed.
affidavit has been filed by the state,
When?
which states that the file is untraceable. So
Earlier affidavit filed, my lord, 2021. Subsequently, my lord, based on coordinate bench of the honorable court, directed us to produce some record, my lord,
Hmm.
and bring that record by way of affidavit. Then, my lord, I entered the office, my lord, office send me an instruction, my lord, that the relevant records are untraceable, my lord.
Hmm.
1991 record, my lord.
Then what to do?
my lord, the matter can proceed, my lord, in the absence of that affidavit, because the facts are clear, my lord. What had happened, subject to your lordship listening, adjudicating the matter today, my lord,
Hmm.
that there was a policy decision, my lord, in the year 1993
Hmm.
of provincializing the services of teachers and non-teaching staff of schools which were already recognized.
Hmm.
The petitioner schools, my lord,
Hmm.
item number 4, 5, 6, 7, and 8,
Hmm.
they happen to come within the ambit of the policy which was notified on 5/10/1993. Now, for some reason, my lord, the names of 5/10/1993, the annexure is at page 25, annexure 1. Now, at that stage, my lord, the government carried out the provincialization of the teaching and non-teaching staff of in the state of Assam pursuant to that policy. That policy, my lord, provincialized 1,255 middle elementary schools.
1200?
55. And the primary criteria of the policy was that prior to that policy, the schools ought to be recognized by the state. Now, subsequently, my lord, the petitioners in 4, 5, 6, 7, and 8, they were provincialized in the year 2013. My lord will come to page 43. Page 43, my lord.
Provincialized in the year?
2013, my lord. Different districts have certain slightly different dates, but all of them, my lord, have been issued in the month of May 2013. For Borpeta, my lord, it was in 16th May 2013. Then for Baksa, my lord, it was 17th of May 2013.
No, these school, where these schools are situated?
Yes, my lord. The petitioners, my lord, what had happened initially was that all the petitioners of item number 5, 6, 7, and 8 had combined with the petitioner in item number 4 to prefer one case. That case was then titled as Honadon Hevashram, my lord. Thereafter, there was an order of this honorable court, my lord, order dated 1/3/2023, where there was a direction, my lord, to file separate petitions pertaining to separate districts. So that is how, my lord, item number 5, 6, 7, and 8 came to be filed. So if your lordship disposes of item number
These petitions belongs to the same district.
same, this
Okay.
different districts, my lord. Initially in
Different.
item, yes, in item number 4, the orders of provincialization pertains to 5 districts. So on 1/3/2023, my lord, this honorable court had directed the petitioners to file separate cases pertaining to those different districts individually. So that is how 5, 6, 7, and 8 came to be filed in the year 2024. Otherwise, my lord, the facts are absolutely similar, my lord. So your lordship can take up item number 4. Item number 4, my lord.
Lordship, I'm appealing for the PCC, Lordship, although I think we don't have much role to play.
Yes, madam.
But Lordship, we are like handicapped, no files are available with us. Any of the files are available with us, none of the files.
No, you obtain it from the Erstwhile Council.
No, they have transferred it, but we didn't get these files, my lord.
Who
in
is
this case.
responsible for the same? Now, can we ask him to again provide the
So we'll
speak
give
to
it
you?
out, my lord, if your lordship
lord.
will be kind enough to give a date to us. This is one matter.
5, 5, 6, 7, 8, similar. Income
And
similar.
what about the other first one?
4 is slightly different, but 5 would be, these have more material.
So, you go through the petition, then we'll hear the matter in the second half today.
My senior seems to have some difficulty, my lord. I have no difficulty, but subject
Once
to.
my hearing will start in division mention criminal ethical lordship understands to go on.
So you have the cases in this court are less important
No,
than
no,
cases.
criminal appeal, my lord, your lordship understands, my lord. I'm also an additional PP, so sometimes, my lord. Tomorrow supplementary test.
How many cases are? So let us do one thing on next Tuesday. Okay.
Wait,
Mr. M. Sharma, learned counsel because of this. Mr. P. Talukar, learned subject counsel for the respondent in limited department. Mr. P. Bhuya, learned standing counsel for the respondent agency. Finance department is there, Mr. Or respondent number? That's our proposal. Finance department. Part in part, list the matter on next Tuesday.
Lordship, we don't misunderstand, man. Every code is precious for us, man. Every code is important
No,
for
no,
us.
after hearing the matter for quite some time,
At the beginning, I thought that my lord not be for my lord.
May I please, your lordship? In this matter, last occasion, this court directed to take instruction whether in respect of petitioner number 1, whether he is working in high school or not. Because the petitioner was left out from provincialization only because of the wrong submission of the date of appointment and in respect of petitioner number 2, date of joining, my lord. Although they have no fault on their part, they are deprived from provincialization since 2013, my lord, till date. Even in the meantime, the several communication was going on by the department to provincialize their services, but till date, nothing has been done, my lord. That in their there is a court direction which I have filed in my additional affidavit 14/8/2024, my lord.
Yes, you are appearing.
I am for the secondary department.
Who is for the elementary?
Element.
Mr. Talukdar, you are appearing here?
My lord.
Nine.
9, 11.
Second day. Second day,
Where is the instruction, Mr. Talukdar?
seven or three order.
Hmm?
24/7 order.
24/7 or 24/7 or 3 display instruction only.
Can it be taken after some time, my lord? I'm good, sir. Okay.
May I please, Lordship? Lordship, we have missed the file in the chamber, Lordship. Matter may be taken up next, any other day, Lordship.
Why?
Lordship, we have missed the file in the chamber, Lordship.
You have missed the file.
Lordship. Even tomorrow, Lordship.
Tomorrow, not possible.
Only hearing there, Lord.
Only
Hearing. Next week only hearing there.
Okay. Part Mr.
K. Kashyap, Lord.
Learned Council. Appearing for
I.H. Soikia.
IA Circle, Learned Council for the petitioner. So Peter, Learned Secretary Education Department. Mr. Take up for
Lordship,
you are for
I am for respondent 5.
respondent number 5. The Learned Council for the petitioner submits that he has missed the file and tries for listing the matter on
2020.
Organized.
Fair enough.
Item 12.
May I please?
Yes.
In this case, my lord, I have given a written brief, my lord.
Pardon?
I have given a written brief. The history of the case is, my lord, the petitioner, he was appointed. He was the founder, headmaster of a school, namely, my lord, Pathartari ME Madrasa, situated in Kamrup district, my lord. He joined service on 1/6/1986. And subsequently, my lord, his service was provincialized, my lord. Now, a scheme came by the government of India, my lord, that the students study for minority community students, my lord. If they, it is applicable to class 1 to class 10, a scholarship scheme. Now, what happened, my lord? The criteria for getting the scholarship is that student must get 50% mark in the previous examination, and the parents' income should be below 1 lakh per year. So it's a post around the society, my lord. The scheme, operation of the scheme was twofold, my lord. One is at the school level, one is at the district level. School level, the school is required to give them the identity, and they are to set that identity, my lord, in a online format. What happened? The school belongs to the petitioner, doesn't have the computer facility. So rest of the work, second limb of the work, my lord, that was done outside the vicinity of the school. Now, the director minority, my lord, department board, my lord, lost an affair. That was on 29/8/2022, my lord, at page 33 to 40. It's like a
Yes.
report. It's like a report, my lord.
Mhm.
There are some my lord, illegalities committed by the schools.
Mm.
The school belongs to the petitioner is not a named, they have not named it. Then, my lord, FIR was registered, my lord. CBI proceeded in the matter, my lord. In fact, the FIR was lodged before the IG CBI. So CBI registered a case and my lord, the case was proceeded.
Mm.
Charge sheet was issued.
Mm.
In the charge sheet, there is no name of the petitioner. Now, my lord, contemplating a departmental proceeding, petitioner was placed under suspension, invoking Rule 6 of Assam Service and Assam Service Discipline and Appeal Rule 1964. That after my lord, issuance of the suspension order, my lord, he preferred a representation, detailed representation indicating all the facts.
When he was placed under suspension,
Suspension, my lord, it was page 43 to 45, my lord, 4/11/2020.
4/11/2020,
20, my lord.
he was placed under suspension.
He was placed under suspension, my lord. On the ground that there are two qualifying, my lord, things. One is that student is a day boarders or hosteliers. If they are hosteliers, they will get little more the amount.
Mm.
And that amount will go directly to their account. There is no question of misappropriation of the fund by the school authority, because school will, verification part of the school is limited to their study and the percentage of marks. Nothing more than that. I have annexed the format
Mm.
that was supplied to the schools. Then suspension was subsequently revoked, entertaining my this representation. Then, what they did, they issued a show cause,
Mm.
at page 46. Show cause, page 46, and I submitted my reply at page 47, show cause is dated 27th of October 2021,
Mm.
and my reply is 3/11/2021. I have narrated the entire facts, and controverted entire statement,
Mm.
After that, page 50, the Director Elementary Education Assam, sought for a clarification or a report
Mm.
from the District Elementary Education Officer, Kamrup.
Mm.
That lordship will find at page 50.
Mm.
A view was sought from the District Elementary Education Officer, Kamrup.
So when the suspension order was revoked,
Revoked,
when?
this is the impugned order, page 59, While revoking the page 59, Annexer L.
Mm.
While revoking the suspension order, they impose a peculiar penalty restraining me to handle financial matters. Lordship will see first the show cause at page 46.
Mm.
What it is. This was issued under Rule 9
Mm.
of the Assam Services Discipline and Appeal Rules. And indication is that why a penalty under Rule 7 would not be
Imposed.
lordship imposed. Now, if your lordship see the Rule 7,
Mm.
there is no such penalty like not handling, barring handling
No,
of
no,
financial matters.
this order is only revocation order.
Revocation order, but a part has been added, my lord.
No, that is not a punishment.
That is a punishment, my lord, because
Punishment can be imposed only after conclusion of the department.
conclusion of the department. My contention is, my lord, that why I have been debarred from handling financial matters, meaning thereby you found some fault in me. In the CBI inquiry, I am not a, my lord, listed accused, nor I am a suspect. Departmental proceeding, I think it is not yet over. Before completion of the proceeding, or not myself being involved in the criminal proceeding, how, my lord, this order can be passed? That is the only.
Now DP is concluded or not concluded?
DP, my lord, after that, my lord, after revocation, there is no communication to me, whether they will proceed or whether they will drop the
Whether, earlier, you have been searched you have been given the search sheet.
lordship. Page 46.
46 is a so cause.
It's a so cause. So cause,
Thereafter, whether search memo was furnished to
no,
you?
no, nothing.
Yes,
If they,
file is
if,
available with you.
Yes, Your Lordship. Lordship, I am on behalf of respondent number 3, Your Lordship, the Director of Assam Minorities Development Board, and we have already filed an affidavit in opposition in this regard. And Your Lordship, the CID is investigating the matter, the respondent number 7, and they were to submit a report in this matter last year, Your Lordship. And FIR was filed and the investigation was going on. CID was. But they have seen evidence respondent number 7.
I have got the search sheet of the CID proceeding, my lord. My name is not there as accused, nor there is any suspect, my lord, in the search sheet, nor I have neither been called by the police. Nothing was my lord, seized from my office. Only their contention is that they are investigating the matter. Against whom, my lord, they have not indicated.
Yes, who is appearing for elementary education? You are. No, Mr. Bora, you say he has been reinstated in his original place of posting. That is as headmaster. What is the basis of this order? Hmm. No, Mr. Bora, you say you have not drawn up any departmental proceeding again. Whether suppose is sufficient. Pardon? Regarding other participants, whether status of the proposal. No, if you say this revocation order was passed on 7th of September 2022. Since then, you have not drawn up any departmental proceeding against him. No, then how you have filed the affidavit? So what is your stand there? Para 5. Page 67.
Elementary, no?
No, Mr. Bora, you say, so who had entered the matter? CID.
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 Respondent number 7.
So CID has not filed any search sheet against him.
No.
Respondent number 7. Okay. No, search sheet has already been submitted. After submission of search sheet, investigation is still going on. Pardon? So Torma, this search sheet is part of the record.
No, no. I have got the certificate with the search sheet. This is the search sheet of the case referred to in the impugn order, page 59.
Hmm.
Column 12, perhaps they say that suspect, any suspect nil. Thereafter prosecution witness.
Column number 12.
Column number 12. They say that there is no suspect behind. Nil. And thereafter the prosecution witnesses, my lord. In the prosecution witnesses also, my name is not there. Nowhere, my lord, there is indication. And in the impugn order, my lord, they have indicated the same case.
So, madam, in the search sheet, nowhere it is mentioned that it is a part search sheet and investigation is still going. Page 30, 65.
No, okay.
Paragraph number? Page? Yes, anything to submit?
Yes, my contention is that suppose investigation is in CBI is going on, then how departmental authority can impose a punishment which is not there in Rule 7 as they contemplated? Because they stated
No.
this is a so-called
That can be imposed only after conclusion of the departmental proceeding. But here departmental proceeding has not yet
No.
initiated against.
yes. Or if they say that 46 is the so-called or charge sheet, even then, it will have to be concluded. While revoking suspension, you cannot invoke any penalty. That too, a penalty which is not in the list in Rule 7 of the Assam Service Discipline and Appeal Rule. And so far as CBI is concerned, they can proceed against me. No issue. Until and unless I am convicted, then only it will be for the department to consider. And so far as departmental proceeding is concerned, they have not said anything relating to issuance of the charge sheet, nor they have said that departmental proceeding is concluded, nor any inquiry has been done. If they go for an inquiry, full-fledged inquiry, I will have to hear me. There are witnesses, there are list of documents as indicated in the page 46 so forth. Nothing. So prima facie, they have issued this impugn order without application of mine. It cannot be. After conclusion of the departmental proceeding, whatever punishment is required, they can impose. Or so far as CBI is concerned, they can impose. But without conclusion of this, how they can proceed? That is the contention of the petitioner. And the suspension was revoked, taking into consideration the report by the block elementary education officer, who clearly indicate it is there, I have endorsed in my page 54. Page 54, my.
Yes.
And page 56, Lordship will find that is in vernacular, my lord. Second paragraph, my lord. Page 57. It is very, very clear, my lord.
Paragraph number?
Paragraph is third paragraph, my lord, last line. Even he indicated that I constructed, my lord, the washroom, and I don't have any, my lord, allegation of my own, because what happened, my lord, my role, Lordship will find at page 42. What is the role of the school? It was a form, my lord. This is a certificate. That is the crux of the issue, my lord. The certificate, it doesn't indicate whether it is a hostelier or day boarder. Only indication is that he is a student. And that too, it is required to be scrutinized by the district level forum. The rest of the part is done by this computer stations, There are some indication in the CBI. They have been found to be doing some illegality.
Okay. Yeah, so what is your submission?
Lordship, we have already filed an affidavit in opposition, Your Lordship, and further we don't have any submission in this regard, and only we are basing on the report, but they have filed and so further, we have, for proceeding, we have to take instruction. We have already filed an opposition, affidavit in opposition regarding our stand. On behalf of respondent number 3, Your Honor.
Okay. Yes, Mr. Bora. Your affidavit is silent in respect of the departmental proceeding. But the question is, can you impose such kind of condition in the revocation order? From the work starting but you say Sarset has already been submitted, nowhere his name is there. But I have to by the chair. That's not but the Sarset is available before this court, but as produced by him. What instruction is required again? Certificate copy is produced before this court. Where is the question of disbelieving it? I have not got. Who is responsible for?
Who is
this? You
responsible?
Certificate copy is produced before this court. Okay, after some time.
What?
Okay. Let her go for this one. Yes, yes, yes.
At 2, my lord. At 2 or
So after some time,
offline?
let her go to the start.
Offline.
Yeah, please, Lordship. Lordship, letter may be passable for time being. My senior is another court.
May it please your lordship. My lord, the petitioner was provincialized under the 2011 Act. One person from that college, one Sarveswar Ali, school filed a writ petition and he obtained a stay order. Thereafter, my lord, that particular case of that particular person was disposed of, directing the authority to look into the matter and decide who is the senior. Ultimately, it was decided that the petitioner was senior and he to be provincialized. In the meantime, my lord, that particular act was declared to be ultra vires. So I was not allowed to be provincialized. I approached this court and the court passed an order at page 70. Facts were there. Relevant is at page 72. Page 72, your lordship will find relevant. From the middle portion, I am reading, madam. I start from, we are aware of the subsequent judgment of the division bench of this court, by which the Act of 2011 was declared to be ultra vires. But for the present case, we find that by operation of law, the service of the petitioner already stood provincialized. But for the interim order of this court, in a situation when another teacher has raised the dispute as regards the seniority, and subsequently by appropriate order, the seniority has been determined in favor of the petitioner. Then the para 5. Considering the matter in the entirety, we direct the Director of Secondary Education to comply with the provision made in the penultimate paragraph of the communication dated 27/9/2016, where the Inspector of School had made a request for taking necessary steps for provincializing service of third arts graduate post of the said school and bring the same to its logical end by passing an appropriate order. In doing so, it is not to be construed that this is a direction from this court to provincialize the service of the petitioner. But on the other hand, it is to be construed that this is a direction to the director of to consider the case of the petition on the facts and circumstances of the case and arrive at his own independent conclusion as to what the nature of order is required to be passed. At the same time, the director should avoid taking the stand that nothing further can be done as the Act 2011 has to be declared to be ultra vires in the meantime. Against this order, they went for an appeal, my lord, and the appeal was dismissed. The government went for an appeal was dismissed. I have annexed that document. My lord, the appeal is at page 83. There is delay and the ultimately delay application, 11 portion, page 84, that their IA was delay condonation application was dismissed. So the appeal was also, ultimately it was dismissed. My lord, we filed in contempt because that order of that court was not complying to it, the direction which was passed by this court. That is at page 78. And at page 79, your lordship has got page 79?
Yeah.
79, my lord, the government appeared and the aforesaid order reveals that in compliance of the aforesaid direction of this court, the service of the petitioner against the third graduate teacher in such a school in the district of Kamrup as per such and such act has been moved to the appropriate department for concurrence. It is also clarified that said order would not be treated as a precedent in other cases. In view of this submission, my lord, this contempt clause petition was closed. So it was closed, my lord, contempt. Now, my lord, when they said that we are complying with, we have sent for concurrence, they passed this impugn order that is at page 91. And the relevant portion, page 93. Against which I am before this court. The man is 58 years, my lord. So he will be returning any day, my lord. So, but they have not filed affidavit, nothing has been done. My lord. Last occasion, my lord, they took time wrongly, it was typed as the petitioner took time. It was not that we took time. Last time they also took time.
Mr. Goswami, you have not filed your affidavit.
My lord,
Interestingly, I have been dragging to this proceeding. You must kindly look in the page 94 onwards.
that similarly one person, my lord, he got.
I am altogether no way connected to the peasant school, my lord. I am working in a different school in a different district, in Nalbari district. Well, my name is, well, this is the petition, the order passed by the Honorable Court, that says 94. Pursuant to this order, Annex 29, page 100, the government implement the order.
My only thing that my friend,
let me complete.
My friend has got a similar order that is the formal.
Please. Yes, Mr. Goswami.
He relied this order. I have no objection to that affair. Not why I am dragging to this proceeding, my lord. I am made party to this proceeding. How can I? I am no way connected to the instant proceeding, my lord. No way, my lord. I am working in a different district, different school. My lord, I may be similarly situated. He may rely my this order.
Is a formal part.
Court is, sir, recently pursuant to this honorable court's interference, the order dated, my lord, 5th, my lord, February 2025 has been passed by the government. That is my lord, fault, my lord. That is why I'm begging to this proceeding, my lord. Can it be, my lord? I am not heard of this kind of, my lord. So my name may be deleted, my lord.
He is a formal party. I'm only thing, I am relying on the order passed by the.
Dragging, my lord.
That is.
I am a poor teacher, my lord. Recently on
It's
February
a formal
month,
party.
my lord, I have been, my lord, getting regular, my lord, salary, pursuant to honorable court interference, the order has been passed, my lord. So why I could not understand why this kind of, my lord, practice, my lord. They can rely, well, they can rely on this order passed by this honorable court in my petition as well, the government's order, my lord. Unnecessary party in the proceeding, my lord.
It's a formal party,
He
madam.
may be,
Formal
his
party.
name, Rasmus number six.
Only
No
thing
one
I am
will be
relying,
elected.
that is why.
He may be, name may be, my lord, deleted in the proceeding.
No, if you are only relying upon the order,
And that,
then why he is a party?
my lord, only thing that, my lord, if he is aggrieved or something, he is only a formal party. I am nothing grievance against him, my lord. I am against the government, my lord. I am relying on the order passed by him. That is why he was made a party, my lord. And the government has passed similar order
No,
to him.
maybe whether any person is required to.
Well, if
be
your lordship wants to
party,
strike
I
it
don't know.
out, then he can be striking out. There is no problem. But I can, my lord, he is only a formal. I'm not saying that he is a necessary.
Okay, Mr. Goswami, we will strike out your name.
Highly obliged.
My only thing is against the government, my lord.
Yes, who is for the respondent?
I'm appearing, your lordship, for second verification. Here, your lordship, we need to file our affidavit.
When?
Finally, 3 weeks time may be granted
Lord,
to us, your lordship.
It will be a futile exercise, my lord, then, my lord. Everything will remain in paper. 2013 onwards in the High Court.
Heard Mr. P.K. Roy Chaudhary, Lord, counsel for the.
There are private respondent as well as here, your lordship, for respondent number 5,
He does.
5 and 6.
That's it, counsel for the.
I'm appearing for 1, 2, and 3.
Get the education department, just make a call for it. Who is for court? Mr. Corposer is for respondent number 4. Mr. UK Goswami for the respondent number 6. None appears for the respondent number 5. Whether service completed in respect of respondent number 5.
Service complete, service complete.
6,
My friend is
so there.
6, my lord, your lordship
six,
can
your
strike out.
lordship, that
Strike
is-
out.
Mr. UK Goswami learned counsel for the respondent number 6, commit said. The respondent number 6 is no way involved in this petition. Then, as such, he can make an extract from the array of this petition. Sir Roy Chaudhary submits that he has no objection in the event of taking out the name of the respondent number 6 from the array of this petition. Accordingly, taking note of the submission of card and counsel for both the parties, the name of respondent number 6, then extract from the array of this. Ms. Peters learned standing counsel for the respondent in secondary education department subject dignity granted some time to file affidavit in fiction. There is accordingly allowed this the matter after 1 week. In the event of failing to file affidavit in opposition on next day, the court will proceed to hear and dispose of the matter without the affidavit of the respondent. Take this time.
1 week.
The number 15.
1 week also, nice.
May I please, Lordship? My lord, today seeks for consideration of the appropriate order, my lord. Lordship, here is the case, my lord. The petitioner was a school teacher, my lord. For the want of criminal case, my lord, affair, he was placed under suspension. Thereafter, my lord, he was reinstated. In the meantime, my lord, police personnel filed the final report that my involvement is not there, my lord.
That final
Then
report
show
is-
cause was issued, my lord. Even after, my lord, I have intimated to the authority by page 52, my lord, that in the criminal case, my lord,
Mr. Corvia,
lordship,
The final report submitted against you is accepted by the court.
That might have been accepted, my lord. That part I do not have instruction. Otherwise, my lord would have got some notice or summon. Nothing as such, my lord. Page 51 be seen, my lord. I have intimated to the authority. It is informed that in the case, investigation authority did not find and submit any charge sheet against me, as I have received character certificate from the Honorable Superintendent of Police as no case against me. Therefore, enclose the certificate along with my cancellation of suspension. I have intimated, my lord. Thereafter also, my lord, page 54, last page, my lord. Departmental proceeding is going on, my lord. And I have been issued show cause notice as at page 47. Okay. That's it.
Mr. Kosek, you are appearing in this matter.
Hello.
Your affidavit is available here.
Well, I'm yet to receive the updated status with regard to the departmental proceedings. Here, my lord, he has already been reinstated. My lord. Petitioner has already been reinstated. Now, we are also unable to know, my lord, that whether the final report has been accepted by the court or not. But unless just that
No, my lord.
position that once, even the final report is given, unless it is accepted, my lord, that would not amount to closure of the criminal.
My lord, page 51 be seen last line, my lord. The Superintendent of Police, my lord, has issued me certificate. I have approached to the authority along with the representation, my lord. 51. Superintendent of Police has no case against me, therefore enclose the certificate along with my cancellation of suspension. So, my lord, the impugn proceeding be stayed, my lord. Today, lordship has fixed, my lord, as per your lordship's last order, my lord. Lordship, kindly have a look your lordship's last order, my lord.
I have gone through the same.
My lord, if they do not file, my lord, lordship will pass interim order. So further proceeding be stayed, my lord. Because, my lord, once I have already, my lord, suspension revoked, criminal case is also nothing against me. And criminal offense is,
No, Mr. Portoya, this information is not available with you right now. That whether the final report submitted by the IO is accepted by the court or not.
all lordship, lordship fix the
You
matter.
obtain instruction, you will let this court know.
Oh, my lord, by at 2 o'clock, or lordship fix the matter tomorrow, my lord. Tomorrow list is, I think, already
Most of the-
published. Or fix on Monday, my lord.
No, Monday, Tuesday. Tuesday. Art Mr. Jay Borgoya, learned petitioner. Mr. E. Kosik, learning subject of for the respondent, elementary education department. During the course of deliberation, Mr. Borgoya submits that after investigation of the case registered against him for this final report. But he has no information as to whether the final report is accepted by the court or not. That view of the matter stands adjourned till Tuesday. So as to enable Mr. Borgoya to obtain instruction as to whether the final report submitted against the petitioner by the investigating officer is accepted by the court or not. List according.
On receiving instruction, my lord, lordship will take pass appropriate order. Either way, my lord.
Item 16.
Bola.
May I please, your lordship?
Hmm.
Lordship, in this matter, the matter has turned infructuous, your lordship. Order dated 4/11/2025. We have not been furnished a hard copy of this order, lordship. Petitioner was placed under suspension, lordship.
Hmm.
After that,
So now we want to withdraw this petition.
yes, your lordship, he has been reinstated, but lordship, one prayer is there. Subsistence allowance, which was entitled by the petitioner after completion of 90 days of his suspension, that has not been granted, lordship.
Yes,
That direction may be passed.
oh, okay. Limited.
Petitioner has already been reinstated, my lord.
But whether this subsistence allowance was paid to him,
My lord, that instruction I don't have right now. Here, as part is.
but there is no payer in your petition also.
Lordship, petitioner has submitted representation, lordship.
No, no, in this lead petition, there is no such payer.
That is there, your lord.
Okay, you go and file one representation,
Lordship.
then in the event of filing such a representation, you dispose of the same by speaking order.
But here is regarding subsistence allowance, fare is not there, only.
There, even he submits that,
My lord,
part Mr.
I'm appearing on behalf of Mr. S. Chaudhary, your lord.
Your name, please.
Kumar Abhinav, your lord.
Learned counsel appearing on behalf of Mr. S. Chaudhary.
Yes, your lord.
Learned counsel for the petitioner and Mr. P.K. Bora, learned for the respondent. In the education department. The learned counsel for the petitioner submits that the grievance being sought to be addressed in this petition has already been addressed by the respondent authority by reinstating him with effect from by reinstating him by order dated 4/11/2025. 4/11/2025. However, he submits that the petitioner, and as such, he submits that he may be allowed to withdraw this petition. But he also submits that he has not been granted the subsistence allowance for the period of suspension. Though no such payer is made in the writ petition. Mr. Bora, learned counsel for the respondent authorities, has produced the order dated 4/11/2025 and submits that the petitioner has already been reinstated. As the petitioner has been reinstated, this petition becomes infructuous and accordingly the same is closed. And in respect of the submission of learned counsel for the petitioner in respect of not granting of the subsistence allowance by the respondent authorities during the period of suspension, it is provided that the petitioner shall file one representation before the respondent authorities, and in the event of such a representation being filed, the respondent authorities shall dispose of the same by a speaking order within a period of dispose of the same as soon as early as practicable. In terms of above this, the WP6 stands closed. The order produced before the court today by Mr. P.K. Boda, an extending counsel order shall be marked as an X-ray and be taken with the recording. You can
Okay.
get a order, copy of the order from him.
No,
This,
no.
this hard copy.
Obviously.
17.
May I please, your lordship? What this case is relating to suspension of the petitioner, your lordship. File dated 14/7/2025, page 35, your lordship. The honorable court directed to pay the subsistence allowance to the petitioner till 4 months, about 4 months elapsed. The petitioner has not received the subsistence allowance as per order of the honorable court, your lordship. Honorable court ordered that your lordship will find page 35, your lordship. But-
Yes, so who is appearing for the respondent?
But neither they have reviewed the matter, no extension, no any action has been taken, your lordship. Neither subsistence allowance given, no review, no extension, your lordship, till then. So hence your lordship maybe, yes, at this stage, your lordship stay the imprimatur order, my lord. Because petitioner, the criminal case also going on and civil case also going on, he has not received the subsistence allowance. Like a slow poisoning, he will die, your lordship. Not even, nothing has been received, anything from the department, your lord.
Nobody is for the respondent?
I am for the limited.
So at this stage, your lordship may kindly stay the imprimatur order, and in the meantime, subsistence allowance may be, order may be passed to give them subsistence allowance. In 4 months elapsed, your lordship, he has not received the subsistence allowance. And there are so many decisions of this honorable High Court, your lordship, and as well as Supreme Court, your lordship.
Fix it on Monday, I'll get the instruction. I'll positively get the instruction.
No, you ensure payment of subsistence.
At that,
My lord.
I'll instruct.
He will die, otherwise you will subsistence nominal amount, your lordship. He has not received the salary, subsistence allowance.
Let him obtain instruction. We'll take it up on Monday. Or Mr. R.M. Chaudhary.
Start date, your lordship.
Yes, Monday, next Monday.
Then Mr. SFT 60, learned Sunday council for the respondent in elementary education
Yes, your
department. Who is for the deputy commissioner? That is common for the respondent number 3. District Commissioner Vishwanath. You for? Respondent number 7. Accountant General. Mr. 60 submits that he may be granted some time to obtain instruction as to whether subsistence allowance is being paid to the petitioner or not. Accordingly, it is provided that rescission is the matter on Monday.
Apply.
10th November. Number 30.
Maybe. Yes. In last occasion, my lord, respondent, they have took time for receive instruction, my lord. And we are filing their affidavit, my lord. Yeah. Area salary, payment of area salary, my lord, petitioner already retired from service in 2019, my lord.
So you have taken 2 weeks.
No, my
time.
lord, it's wrong, wrongly, is my lord. Actually, they have taken time, my lord. They have
Who is for the respondents?
secondary education.
Where is your affidavit, Mr. Assistant?
Actually, I think we have not.
Are you interested to file your
Yes,
affidavit?
yes, Lordship will file it, Lordship within a week, Lordship will file.
Or Mr. AK has not learned.
In fact, we are, yes, Lordship, we need some more time because I have got a instruction that the record was sent to us, Lordship, it was somewhere misplaced. Lordship, can you give it 2 weeks time, Lordship?
Mr. Assembly Assistant learned Standing Council for the respondent in elementary or
Yes, Lordship, secondary, Lordship.
secondary education department and madam
Is your for respondent number 5, Lordship?
respondent number 5 AG. Non-appeals to the respondent number 6.
Yes. Director of pension, government, director of pension is a government. Okay, director.
Mr. 60 submits that he may be granted 2 weeks time to file affidavit in opposition. Fair allowed for the last time.
Yes, Your Lordship.
In the event of failing to file the affidavit in opposition within 2 weeks, the court will proceed to hear and dispose of the petition without the affidavit. Respondent need secretary to the department this for 2 weeks.
Can I pay date, my lord?
26 November.
Alright.
Item 31.
May please, Lordship. Matters regarding provincialization of service, Lordship. In respect of similar matters, Lordship, this honorable court was direct the respondent authority to file their affidavit after 2 weeks. And so these similar matters are listed on 1711, Lordship. So matter may be taken along with this bit.
1711.
Yes, Lordship. WBC number 4331/25. 4331/25.
Okay.
Similar matter also list for the 70.
Suppose where is your affidavit?
What affidavit is not yet signed off. Let it come up on 1711. We'll check up on whether affidavit is signed on that.
Or Mr.
MS Mondal.
Learned counsel for the petition. That's the big learned standing counsel for the respondent. Part. The learned counsel for the petitioner submits that another petition take WPC number 4331 of 2025 is pending before this court. And the same is listed on 17/11/2025. And as such, this matter may be taken with the permit of the petition WPC number 4331. There is accordingly allowed places and list the matter on 17/11/2025. And in the meantime, Mr. Kosik learned standing counsel for the respondent, Secretary Education Department, shall fight the affidavit.
Right. Lordship.
Number 18.
Yeah, Lordship, we have issued the compliance order, Lordship. They can be there. I cannot. Yes. Oh, he has received it, Lordship.
direction the para 18 lawsuit, petitioner is to submit an appeal that has to be disposed of by the secretary. And lawsuit may kindly turn to para 20. In the event on the consideration of the matter, the appellate authority, the secretary, government of Assam is of the considered view that petitioner is not eligible to have his service provincialized in the state school. The appellate authority shall issue a speaking order in this connection, incorporating the reasons thereby. So that speaking order has been issued lawsuit. That the petitioner is not, that after careful consideration lawsuit of the above, all other aspects, it has been decided that the claim of the petitioner for provincialization of his service cannot be considered as the required 6 years of continuous service as laid down under the section 423 of the Assam Education Provincialization of Teachers and Reorganization of Education Institution Act 2017 as amended 2018 in aspect where the petitioner is doubtful. So he doesn't lawsuit qualify for that provincialization. Now he has to challenge this also.
I have already received a copy earlier date.
Yes. So we'll close this petition then.
Close.
Heard Mr. and Islam, Garnet Council for the. That is the thesis. Council for the response. Product of that part. If the council is for this one product, compliance order. It did 22nd of October 2025. 2025. The learned counsel for the petitioner submits that this petition may be closed and he will challenge the order dated 22/10/2025 passed by the respondent. Secretary to the Governor of Department of Select People according to Para, taking note of the submission of learned for both the parties. Petition stands closed. The order published before the court today shall be marked as an extra text and take to the record.
Bless.
Right, please allow. 19, I have received an order issued by the Secretary of Office. I can look from the whereby lawsuit, though the petitioner's prayer for their where school is concerned, that has been rejected lawsuit, but the student is concerned lawsuit, they were directed to lawsuit take admission in the nearby provincial school, and all the inspector schools have been directed to facilitate that process lawsuit. The inspector schools of a concerned district shall immediately take steps for arranging the alternative schools for any willing students, and in coordination with the ASSEP Division 2 shall specially register their names in the DORPON portal from the preferred, permitted, or provincialized or government school as per the student's preference, so that the academic pursuit of the students are not hampered.
Yes, Mr. Chaudhary.
Yes. If a lordship would kindly come to the order in respect of which I'll deal with this order little later. Please come to page 84 of the contempt petition, my lord.
Yes.
And to be more precise, if a lordship would kindly come to page 83, para 34, last sentence. In view of the foregoing discussion, I am of the considered view that respondents deserve to be directed to consider the case of the petitioner for according permission and to allow to conduct admission for higher secondary first year classes onwards in their respective schools. Accordingly, respondent authorities, namely Secretary to the Government of Assam, Secondary Education Department and the Director of Secondary Education, as well as Assam Higher Secondary Education Council, are directed to consider the case of the petitioners within a period of 3 weeks from the date of receipt of the certified copy of the order. Consequently, impugn order dated 14/9 issued by the Secretary to the Government of Assam, impugn communication dated so-and-so issued by the Director, and the impugn order dated issued by the Director are set aside and quashed. My lord, this order dated 14/9, or before that, now if your lordship would kindly take the order which has been handed over by my learned friend, my lord. In the first page, last but one para, after due discussion in the meeting held on 4/11/25 and on perusal of the report submitted by DSE dated so-and-so, it appears that all the schools where petitioners are working are private institutions and are functioning without government permission. So, my lord, this order proceeds on the basis that there are no government permission in our case. My lord, in the writ petition, we have annexed everything, but for the ready reference, we filed an additional affidavit. It starts at page number 93, my lord. Please come to page 99.
Yes.
Actually, my lord, this permission was granted on 22/4/21. Subsequently, government by this 14/9/22 letter wanted to say that it is not government permission. With reference to the above, I am directed to clarify that government letter dated 22/4/21 is not permission in respect of the higher secondary schools as mentioned under letter under reference. Well, this order has been set aside and quashed, meaning thereby there is permission. Now, how can government take this stand, my lord? This order of 22/4/21 was construed to be not a permission, which was set aside by this honorable court.
This is a letter by the secretary to the.
It was by the secretary. My lord, certain things may not be done in form, but in substance it is done. In the peculiar facts of this case, my lord, its permission was given. Though it was not in form, therefore government took this stand, we challenge this order, and our writ petition has been allowed. After setting aside, they have been directed to consider. Now, my lord, without appealing against that order, can they take this stand? Is it not contempt, my lord, prima facie? There is an order, there was an earlier order where the government wanted to say that this is not a permission. That order was interfered with. Then matter was remanded to the authority to consider. That means, while this honorable court directed them to proceed in the matter, the presumption was there is permission. Now, can they sit in appeal over that? That's the issue.
So far students are concerned that we have already.
It's not a question of students. Student plus school all have a right.
So that they do not lose their academic career losses. That is there.
So my submission is, my lord, without that order has attained finality, order in respect of which we are alleging contempt. Now, in that order whereby it was said that there is no government permission has been specifically interfered with. In that view of the matter, my lord, now can they say that because there is no permission, they cannot be permitted? This honorable court came to the conclusion that there is permission.
In this point, then may kindly give me some time to get a instruction. What my learned senior friend has said. Otherwise, so far students are concerned that their interest has been protected. They were allowed to take admission in the provincialized government school, and all the inspector schools have been directed to facilitate.
Can you tell me whether such institutions are available in nearby?
Yes.
Yes. These are all available. In fact, all these institutions were established, some of the institutions established in the premises where the government school, senior SS school is there. Lordship.
Between
It is in
95
the
and
same campus.
2005, our schools were established.
It is, some schools are within the same campus. They don't have the permission, but they are established within the same campus with the government school. Lordship.
No, no.
Up to class 10, 14, and 11 and 12 is 5.
Yes.
Same premises. The
No,
rest is
now the question is what Mr. Sisti has submitted, that the interests of the students are protected.
Yes.
Now you tell me whether such kind of institutions are available in nearby with the present.
Yes. If it is not by nearby.
Yes.
So the nearby, if it is any school is not available, the nearby school that will take over.
Then how their interest is protected if
yes,
such
the interest is
institutions are not
Nearby may
available?
be 5 kilometer also, nearby could be 3 kilometer also. Because
Yes, yes.
No, 11 and 12, how many students? Few students, not more. Few students, how many 30, 20, 50 like that, but there can be a competition.
My lord, I think the authorities should consider one thing, my lord. We know there is no ideal situation. We do not have the adequate infrastructure. We are trying to build it. But then, my lord, there will be some hardship somewhere. But then, my lord, end of the day, these are the issues pertaining to the student. I think government should take a liberal approach, my lord. Now, how can they say that there is no permission? Their only ground is that since there is no permission, we cannot permit. But that stand of the government was rejected, and that order has attained finality. Court, this honorable court, after setting aside that order, remanded.
Actually, their letter. 22nd April 2020, and that is correct. It was not set aside, and it is after, according to the meaning thereby, this letter is not a permission. Which letter communicated to us that it is not a permission that has been set aside. So they are saying, petitioner saying, because this letter is there, not set aside, it's debated. But this letter is not a concrete permission. It says you verify if it is, I am reading this order. This is the letter. Inviting a reference to the correspondence quoted by.
See, now we are in a contempt proceeding. We are not on the merits of the case.
Contempt proceeding, rightly, wrongly, we have already complied it with. If it is necessary, they can challenge it. It is between court and contempt. It is has no role to argue this. We are taking care of the student. So this letter, my lord, APS letter, my lord, in view of the feasibility report issued by the council.
Mr. Sutia, you have no option to submit before the court that you are rightly or wrongly complied with the order.
Yes, past the speaking order.
You have to comply with the order in its letter and spirit.
Yes.
Letter in spirit, my lord, that's why, my lord, that letter we have, my lord, written to the director. Against this letter, today they have submitted a reply. The reply is this one. So how can we, my lord, comply? We will have to abide by that. Our this letter, my lord, on 13 October 2025. Against this letter, my lord, we wanted a order in the form of order, my lord.
No, Mr. Sutia, you see, this letter dated 14/9/2022 has already been set aside by this court. Then
this letter is not, my lord. This letter set aside.
14/9 is set aside.
14/9 is set aside. This letter says that this letter 22 April 2021 is not a permission. That is set aside. Meaning thereby it is a permission. They are saying. But this letter is not concretely. That's why I am going to read it. I am going to read it, my lord. In view of the
I have no objection to my learned friend reading that letter, but contempt law is very clear. In a contempt proceeding, court will see whether there is, lordships will not pass any further direction. Lordships will only see whether there is violation. If there is violation, then action is to be taken. Now here, there is no question. I think my learned friend is also aware, Miller. There is no question of reappreciating the thing. Can I put? It's a pure and simple, you have not appealed against that order. That order has attained finality. That order may be a wrong order, but that order has to be followed.
Mr. Sisti? Yes. So this secretary is not the appellate authority of
No, he is not the appellate authority. No, that is not.
Then,
Definitely not lordship.
then you have not filed any review petition or an appeal against that order.
That's
So
what.
that
lordship-
order has already attained finality.
Oh, it is 24. 25 or 25.
Lordship may kindly fix it on next week any day. Lordship. I'll get it.
Not next week, tomorrow. Tomorrow at.
Otherwise the interest of the student, they were.
No, no,
intact,
no,
lordship.
no. That is a vague
And
answer.
if it is permission
No,
is,
no, no.
lordship is honorable court has held that permission is there, then the board should not have asked for another for written instruction lordship.
In the
They
form
could
of
have,
order.
they could have immediately include an immediate drop on portal lordship.
Permission is not there, that's why, man. That letter is not concrete order. They say you examine and verify.
No, that
It was issued only
interpretation,
because the board has issued a letter to us whether the permission is there or not.
that interpretation of that letter is not available now.
Yes.
This letter is which we read petition on page 84.
You,
It is not in the contemplation.
you go and file an appeal or review petition
Yes, yes.
if you want to argue on that point. But now you are not allowed to argue on that point. Either you have to comply with the order or to face the consequence. By tomorrow at 2 p.m. you have to apply.
No, tomorrow.
Because lordship,
And you
this drop on
also,
portal is managed by the.
no, you also let the secretary know that he is not the appellate authority of this court.
No, absolutely not, Lord. No.
But somewhere the instructions are not in the proper
Yes.
form.
That is because the board has written to us whether permission is granted
No.
or not. That is why we have said it is not these are not permitted from school lordship.
No, then better instead of passing this order, you could have asked them to allow them
Comply with the
grant them
order.
permission to open the
Door
portal.
So, my lord, that's why, my lord, we confuse it, my lord. If it is taken as a permission, then we can open it. But government says it is not a permission, but that letter has been set aside.
no.
That's why Mr. Soduri Senior Advocate saying that if it is set aside, then already 22 April 2021, granting permission is affected. That's why we should comply with. That's why we wanted a concrete order in the form of order from the government. You will tell us whether it is permission or not. If it is permission, then we will open. We are ready.
That was also not required because honorable court has already said. Everybody is, my lord, passing the buck.
No, board only says, but there is no direction that this letter is to be taken as a permission. But only say other letters are set aside, but they have not said anything about this letter. There is a permission.
No, that letter has been set aside.
The other letter is set aside. I understand, ma'am.
49, that letter is also set aside.
That said that it is not a permission.
Oh, yes, that letter is set aside. That's why meaning thereby that this letter is permission.
Permission.
That's why the whole problem is, my lord.
No,
the-
Mr. Sutia, this way you cannot argue the matter before this.
No, I will obtain instruction on whether they are planning to file any review or appeal or comply with.
By tomorrow at 2
Yes,
p.m.
Yes,
Tomorrow.
As agreed by learned
We will inform
advocates
her
of both
tomorrow.
the parties, the shall list the matter tomorrow. And in the meantime, Mr. SMT Sisti, learned counsel put a contender number 1 and 2, and Mr. Sutia shall obtain necessary instruction and attend this court at 2 p.m. tomorrow.
Deploy.
Timing items, item number 29 for motion.
Let's little. Lordship, here petitioner is a head teacher of LP school, my lord. Page 29, by this letter, by this order, my lord, the district elementary education officer accorded approval to shift the school. There is nothing, no direction to the petitioner to shift the school. Nothing is there, my lord. Then, my lord, annexer 5, page 34. By this order 16/9/2025, my lord, the district elementary education.
Yes,
officer-
madam, where is your affidavit?
My lord, instruction is there.
So there was direction to file your affidavit.
No, my lord, actually, I have prayer for instruction. My lord, here, my lord, Director Elementary talked with the CEO Mankasa after.
some development is going on, one hearing was done. So, madam, kindly, in this case, notice maybe, so in the meantime, we will file affidavit. Without issuing a notice, it is very difficult for us to place instruction. And kind of, direction was issued to the petitioner to shift the school, madam. Only because of one person, all the.
No, whether that order was communicated to him.
Yes, madam.
When?
But he denied, madam, to shift
That
the
is-
school, madam.
No, where is the endorsement that he has received this notice, received this letter?
Not, my lord. This is no endorsement, nothing. I have not been served.
So, madam, my humble prayer is that notice may be issued. So in the meantime, we will file affidavit accordingly, madam. In this case, notice was not.
And my submission, my lord, I am on law point, my lord.
No, madam.
The another, my lord, he has no authority. He is not the competent authority under the rule. DO cannot suspend me, my lord. Only the director can suspend me. And DO can do it by after getting approval from the director. That is not done. So it is violation of.
A letter obtain inspection.
Yes,
a letter file affidavit. We will transfer 1 week time.
Till then, my lord,
Which time may be allowed?
No 2 weeks.
my lord, the 127, 2710, my lord, I have filed an additional affidavit, my lord. They have issued another order when the matter is sub judice, my lord.
No, this is like this.
No, my lord, here is violation of rule, my lord. So it, my lord, this court is,
This is a suspension matter. So we-
suspension is, it should be as per rule, my lord.
Proceeding on.
Without following the rule, it cannot be, my lord.
Please sit down. Sit down.
My lord.
Letter complete. Yes.
Well, this is a suspension matter, so we have to draw the departmental proceeding, madam. So in this case, we need some time, madam.
No, madam, earlier this matter was taken up on 17/10/2025. On that day, you have asked for time to obtain instruction.
Yes, I know, but
Then you have also prayed for time to obtain instruction as to whether the approval from the Director of Elementary Education for placing the petitioner under suspension was obtained or not.
but that is.
Whether approval was obtained.
That instruction not applicable to me, but.
Available, but it was your
You,
pair
my
on, it was your pair on 17/10/25.
Yes. 1 week time may be. And madam, kindly notice may be issued.
Art Mr. Khandokar learned.
My lord, may I say one thing, my lord? The impugned order itself says, my lord, page 38. Approval is pending. My lord, page 38. Approval is pending. It itself says. Last para, my lord. Page 38, last para. Therefore, pending approval of the Director Elementary Education Assam and on urgent note, need of the institution, so and so, teacher is thereby placed under suspension. Approval is, order itself. shows.
Letter file an affidavit. Also heard Ms. Anne Kokon, learned London Council for the respondent in Elementary Education Department. In this petition under Article 226 of the Constitution of India, the petitioner has challenged the order dated 20th 9/2025 issued by the district elementary education officer, South Salmara Mankasar, Patchingimari. It is to be noted here that by review order dated 20th-9/2025, the petitioner was placed under suspension with immediate effect. Ms. Upon learned standing counsel for the respondent in elementary education department commits that this matter notice has not been issued, then she may be granted some time to file the affidavit in opposition. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that notice be issued to the respondent.
1 to 5. I am appearing 1 to 5.
Returnable in 1 week. However, no formal notice is required to be issued to the respondent number 1 to 5 since it's open. Entered appearance and received notice, however, extra requested copy of the petition is filed to her, furnished to her during the course of the day. Step upon respondent number 6. Whether respondent number 6 is a party here. that's a
Yeah.
Party here.
How?
My lord, respondent number 6 is the CRCC, my lord. He has been, my headmaster, part of headmaster has been taken away and given to him. It is also.
Okay,
without-
then you serve upon him notice upon him by Dusty Mut.
My lord, Dusty, my lord, is to be through the DO, my lord. Through the DO. Respondent number 3. my lord.
Step upon respondent number 6 be taken by reserve post with ADN also by usual process within 1 working day from today. Additionally, Dusty service is also permitted. After taking service upon respondent number 6, the petitioner shall file one affidavit before this court. It also appears from the order dated 17/10/2025 that is spoken learned and standing counsel for the respondent in elementary education department directed to obtain instruction as to whether the district elementary education officer South Salmara Mankasar has obtained approval from the director of elementary education for placing the petitioner under suspension. But today she submits that such information, such instruction is not available with her. Rather, she prays for time to file affidavit in opposition. Where is accordingly allowed. This is the matter on
14 November.
14 November. In the meantime, Ms. Popon shall file one short affidavit regarding obtaining approval from the Director of Elementary Education for placing the petitioner under suspension. And also, in respect of service of the letter dated 11/7.
My lord, the letter, yes, ma'am.
11/7.
11/7/20.
11/7/2025 to the petitioner. This the matter on 14.
That's the one thing. my lord.
Interim pair of the petitioner will be considered on that day.
One thing, my lord, I have filed additional affidavit. There, my lord, on 27/10, they have issued one letter to me to hand over stars, my lord. Till then, my lord, only no coercive action may be taken up, but in terms of this letter, additional affidavit, page 48.
During the course of deliberation of Mr. Mandokar has also drawn the attention of this court to the annexure 1 of the additional affidavit. A letter dated 27/10/2025, wherein the petitioner was directed to hand over the service. While not granting any stay on the aforementioned order, it is provided that any action taken upon the petitioner herein pursuant to letter dated 27/10/2025 that is subject to the outcome of this writ.
I'm deeply.
Coming item 9 for admission.
In respect of the petitioner number 2, my lord, the proposal that has been sent by the state level scrutiny committee is pending before the government matter. As of, let this matter come up in the first week of December, my lord.
First week of December. Yes, ma'am.
First week of December, 4th of December.
4th of December. Yes.
But
Or-
my lord,
or-
in
or
respect of-
Garden Council for the petition. So P46 are sending out for the elementary education department. The PO6 submits that the matter is now pending before the state level scrutiny committee,
It is pending before the government.
pending before the government.
In
And
respect of
that's the-
petition number 2.
In respect of petitioner number 2, and in respect of other.
Petition number 1, my lord, already is, it has been rejected, my lord. In affidavit, we have, lordship will decide.
Lordship, in respect of petitioner number 1, my lord, I have going to say that the petitioner number 1, the lordship kindly peruse the page 35 annexure 10, my lord. Page 35 annexure 10, that I am reading in the second paragraph. It may be mentioned here that the name of Dulal Sharma was not recommended earlier by district level scrutiny committee for provincialization of service due to his date of joining. Now DLRC Lakhimpur has recommended and submitted the proposal showing that the date of joining is 27/2/2010 instead of 22/6/2011 in respect of Dulal Sharma, science teacher of Bhati Medak ME School. The relevant document in respect of Dulal Sharma as science teacher of Bhati Medak ME School are enclosed for ready reference. In view of the above, the Gov is required to take necessary step for provincialization of service in respect of Dulal Sharma as science teacher of Bhati Medak ME School as an early date. That letter was submitted by the Director of Elementary Education to the Commissioner and Secretary to the Gov of Assam on 19 June 2015, my lord. The new act has come on 2017, my lord. After recommendation, they are sitting over for 2 years, not provincialize the service of your petitioner. So, and thereafter also they are communicated to provincialize his service, my lord. Now they have said that his service was rejected, my lord.
But this is a communication of 2019 till 2015.
But
prior to the act got struck down. After the act has struck down, all orders, all acts for the communications for the stands repeal as per section 24 of the new act.
But new act has come only on 2017. Before 2 years, my lord, already director has submitted the proposal, my lord, and they have not provincialized the service of petitioner. And why they have not provincialized the service of petitioner, that should be brought on court, my lord, on the next date, why he has left out, my lord. That instruction must be submitted.
No, whether it is explained in your affidavit.
No, my lord.
why the matter was not
My lord.
considered before resealing of the.
So there is in the affidavit that is, so what happened was in respect of petition number 1, the school in which the petition number 1 was serving at prior to the ventures, prior to the provincialization, that school after provincialization has been amalgamated with the second. The secondary education department has filed an affidavit, director has filed an affidavit, and a report of the inspector of schools has been brought on record by page 106.
Let us do one thing. Let him apply instruction. Will finally hear and dispose of that.
Yes. Otherwise also, my lord, the claim of the petition number 1, claiming provincialization under the Act of 2011, my lord, my respectful submission, that cannot be granted, my lord, because there are
But
things-
you have to explain why you set over the matter for 2 years.
Yes.
Which say, what is there in your affidavit? Ms. Bodarbora, allotted for the petition.
December 6th.
It's 46 submits that case of the petitioner number 2 is pending for the government, and if press for the matter the first week of December, there is allowed, let's pick up it for matter of 4th of December.
Grateful.
Serving letter 12
have gone to the third sheet, my lord. Here,
Yeah.
my lord, this is pertain to my lord, Borpeta, Torong, Dhuburi and Gwalpara. Kindly see internal page 100.
Yes.
Conspiracy and fact discovered during investigation column.
The petitioner belongs to who is this thing?
Kamrup.
As per my instruction, Lordship, investigation is going on, it is approved and some others. Only this 4 district has been already completed, Lordship. The fact sheet has been filed, Lordship, against it.
No, even then, without a DP being initiated against him and without a search sheet being filed against him,
No,
can you impose such a condition?
no DP has been initiated against him as per my instruction. My initial proposal was to, thereafter hearing was held, my lord.
But then how can you impose such a condition in the revocation order?
Well, only thing is that we have imposed that, my lord, till completion of the EML pending rural department outcome of the CID PS case number so and so. That is Abdul Kudur headmaster sir, hereby reinstated in his original place of posting for utilization his service except, my lord, work related to financial matters.
No, can you do that?
My lord, he may, my lord.
Under which provision you have done it?
Only thing is that because CID investigation is going on, that is why, my lord, he may.
No, whether that is explained in the order.
They have quoted a wrong number. They have quoted the wrong number. in the search sheet. The impugn order, the case number is the search sheet I have submitted where my name is not there.
Chairman, kindly see
Page
the
59.
Yes.
kindly see the affidavit filed by the government, my lord.
Yes.
Number.
Only please that investigation is going on against whom it is not there. I have submitted the search sheet. Search sheet, my name is not there. The impugn order, they have mentioned the case number. Of which the search sheet is before your lordship. Even presuming my name is there in the search sheet, it has got nothing to do with the departmental proceeding because departmental proceeding has not been initiated.
Kindly see
By a criminal proceeding, whether a punishment can be imposed. Without holding inquiry, without holding any departmental proceeding, no punishment can be.
Kindly see page 72 of the affidavit filed by the government, my lord. Respondent number 7. Page 72, my lord, para 2, my lord. That the investigation was carried out at various districts of Assam and collect the evidence in as much as the involvement of the headmaster in the associate in the above illegal. Accordingly, 43 perpetrators have been arrested as of now and forwarding to jail custody. It is to be mentioned here that the search sheet has been filed against 32 numbers. That is why there are 32 numbers is there. Remaining investigation is going on. And here, my lord, specifically mentioned regarding the petitioner. Kindly see page 74.
No. That is not the issue before this court. Whether investigation is going or not going. The issue before this court is whether you can impose such a condition in the revocation.
Only defaming him from
whether you are authorized by any act or any rule to impose this condition.
only we are expect, kindly see, work related to financial matters only.
Yeah.
Other, he can execute, my lord.
Yes,
Except financial matter, my lord, because he is involved in misuse of finance,
misuse of,
misuse of money, my lord, allotted to the students as a scholarship.
no. Without initiating any DP, then completing the same, then arriving at a finding that he has embezzled some of the amount. Can you impose such punishment?
Because CID investigation is going on, that is why. Investigation has not yet completed, my lord. Because as per the report, it is clearly reflected that his involvement is there.
Where?
Page 74, man.
No, we are not going to decide that issue. That is not the issue before the court.
Let the CID file their.
You answer my question, whether your order is backed by any act or any statute or any rule?
No.
No. Then answer is clear. Okay, Art Mr. S. Sharma, learned. Mr. P.K. Bora, learned something council for the respondent in elementary education department. Ms. Bormon for respondent number.
And for
And 7, Mr. Kaichop for respondent number 3. Argument concluded, order reserved. It is certified copy of your third sheet. You can obtain from the court master later on.
Later.
Not now.
Obliged.
Parting with the case method. Today I'm going to find the affidavit in some professional. I am seeking to complete it.
Affidavit
For the response number 6, 7, and 8.
7 and 8.
My lord, lordship may kindly see. Are you calculating?
Number.
Earlier, your lordship was imposed post, and thereafter, my learned friend had taken time. Now today, he is saying that.
Today it will be my
This cost is deposited.
Oh,
Sorry, my lord, I am not able. I have to, my lord.
it's order
If it is
dated,
not
my
for
lord,
deposit, I have to.
29/8/2025.
If it is not deposit, I will make.
Sir, do you think current counsel for the petitioner? Mr. Sharma for respondent number
6, 7, and 8, my lord.
6, 7, and 8. Let's open for respondent number.
Another department.
Something counsel for the respondent in elementary education department. Madam Bormon for respondent number 3. Mr. Sharma submits that he may be granted some time to file affidavit in respect of respondent number 6, 7, and 8. So Sharma,
Madam.
your prayer for granting time to file affidavit was allowed on 29/8/2025,
Yes.
subject to payment of cost of rupees 5,000. But till date, you have not filed the affidavit in opposition
Madam,
and also not deposited the cost.
Thereafter, on 19/9/2025, he has taken time again.
On that day, my lord, I was absent perhaps, so far the cost part is concerned.
We will impose another 5,000 cost today.
My lord, today, my lord, I am going to file. It is already, my lord, perhaps filed.
We
it
have
is
not received.
His phone number is not getting, my lord, so it will be, my lord, start today also.
My lord, this is pending since 2023, my lord. Is it terms of 3 years, my lord. Already more than 2 years. Okay, my lord.
let the matter be fixed on Monday, but today it will be competent. Airport will also come, or even by tomorrow may also be.
It also appears from the order dated 19/9/2025 that on that day also Mr. Sharma has tried for granting in time. And further, it appears that Mr. Sharma has not deposited the cost amount of rupees 5,000 imposed by the order dated 29/8/2025. Today, again, Mr. Sharma has tried for time. There is allowed, subject however to payment of cost of rupees another 5,000, which shall be deposited before the Advocate Welfare Fund of the Guwahati High Court Advocate Association, Bar Association. And Mr. Sharma shall produce the receipt, deposit receipt before this court on next date. This the matter on
19 November.
19 November.
Yes. So far, the imposition of cost is concerned. I have already made ready matter.
Sorry.
That part is not, that may be my. Fine.
Items for hearing 20 and 21.
That is lordship. But on the last occasion, lordship, the respondent numbers 1 to 4 were given liberty to file affidavit lordship bringing the IT and income tax return as well as the salary last year of the husband of the deceased lordship. That was done as a file loss on that purpose. Only extra purpose.
Yes, Mr. Goswami.
I have received that, so I'm satisfied with it, Lordship. One part of my objection goes not.
Okay.
The only thing that remains in my appeal is, Lordship, again,
Your
Lordship,
only part is?
only part that remains of my appeal, Lordship, is something I have to leave it to the discretion of the Honorable Court.
So what is that?
That is interest, 9%. Lordship, interest is a matter of discussion of the Honorable Court, Lordship, of the tribunal. I always keep saying that, Lordship. But it again, Lordship, is varies from facts and circumstances. It's not uniform. Even Apex Court, Lordship, gives more times less than 9% than the 9% that has been awarded here. In some cases, the Supreme Court gives 9%.
What is the
I can only pray for only Lordship here.
No, what is the rate of interest awarded by the tribunal?
9%.
9%.
And in most cases, even now, Lordship.
Whether any reason is assigned for awarding
No reason has been assigned. It's never hardly assigned. Never. So in the facts and circumstances, Lordship, I can only say where the amounts are high, maybe a lower rate of interest more than offsets compensates their loss. I can only make that prayer, Lordship, and I leave it to you, Lord. Because even Supreme Court, Lordship, awards more often less than 9% than 9%. Even now, Lord, I have been going through all the judgments. So that's only, I can make only that submission. I have now greater submission, Lordship, in respect to other cross subjects appeal filed by my lord.
Who filed the cross objection?
By the owner of the bank. Because Lordship, in this case, Lordship, I was given the remedy of pay and recovery. There is no permit. Lordship, I'll come because Lordship may come to that part of the judgment, Lordship. Para 13, Lordship. That
it says, subject to the condition that the OP number 3 HDFC Argo GIC shall be at liberty to recover the entire amount paid to the claimants from the OP1, namely, say, Gunojit Nath. No separate proceedings shall be required to be instituted. And Lordship, the tribunal had based its this particular finding, Lordship, from it starts from page 9. Page 9, Lordship, was the last, but the offending tipper, it's a big vehicle tipper, is as such accepted to be covered by a valid insurance policy exhibit A issued by OP number 3 company on the day of accident. The OP number 3 has put forward a second line of defense that the offending vehicle was plying on the day of the accident without any valid permit issued by the concerned authority. This argument, however, seems to be vital and sound, which hits the right point as desired. It is an admitted position that the offending vehicle tipper dumper did not have any valid permit on the day of accident. The argument of the learned counsel for the OP1 that the vehicle, being a brand new one, was only being taken to garage for fitting of accessories is of no good and cannot be used to rescue the OP1 from being the liability for payment of compensation. However, in consider the fact that the offending vehicle is covered by valid insurance policy, the initial burden for payment of the compensation shall be borne by OP1, subject to recovery of the entire amount. So this Lordship will may need a written statement, Lordship, of the OP1. There's not a single averment about there being a permit or for why the permit was. I have the copy of the written statement with me. It talks about, Lordship, policy, driving license, but no single averment, not even a word, not even the ground why it was not obtained. Is there in the written statement. Para number 5, it says a vehicle dumper 10-wheeler was being covered by a policy of insurance. Number 6 says there is a driving license. There's nothing, no averment about permit at all. Also, in this context, Lordship, I would like to rely on 2 citations on this point, Lordship. One is, Lordship, I'll pick your Lordship stated to para number 12, Lordship. It discusses the entire this topic. This is para number 24, Lordship.
Yes.
In the case at hand, it is clearly demonstrable from the materials brought on record the vehicle at the time of accident did not have a permit. The appellants had taken the standard vehicle was not involved in the accident. That apart, they had not stated whether the vehicle had a temporary permit or any other kind of permit. The exceptions that have been carved out under Section 66 of the Act, needless to emphasize, are to be pleaded and proved. The exceptions cannot be taken aid of in the course of an argument to seek abolition from liability. Use of a vehicle in a public place without a permit is a fundamental statutory infraction. We are disposed to think so in view of the series of exceptions carved out in Section 66. These situations cannot be equated with the absence of a license or a fake license or a license for a different kind of vehicle or, for that matter, violation of a condition carrying more number of passengers. Therefore, the principle laid down in Saran Singh Lakshmi that would not be applicable in the case in hand. That apart, the insurer had taken the plea, the vehicle in question had no permit. It does not require the wisdom of Tripitaka that the existence of a permit of any nature is a matter of documentary evidence. Nothing has been brought on record by the insured to prove that he had a permit of the vehicle. In such a situation, the onus cannot be cast on the insurer. Therefore, the tribunal as well as the High Court had directed that the insurer was required to pay the compensation amount to the claimants with interest, with the stipulation that insurer shall be entitled to recover the same from the owner and the driver. The said directions are in consonance with the principles those stated in Sharan Singh and others pertaining to pay and recovery principle. In view of the above, we did not perceive of any merit in the appeal. Accordingly, same stands dismissed. Lordship, I'd like to conclude by relying on just one another side, Lordship. National Insurance Company versus Challa Bharatamma. Para number 12, Lordship. Para number 12, may I read out, Lordship? The High Court was of the view that since there is no permit, the question of violation of any condition therefore does not arise. The view is clearly fallacious. A person without a permit to ply a vehicle cannot be placed on a better pedestal than vis-a-vis one who has a permit but violated any condition thereof. Plying of a vehicle without a permit is an infraction, therefore, in terms of a defense available to the insurer on that aspect. The acceptable stand is a matter of a judicial. The question of policy being operative has no relevance for the issue regarding liability of the insurer. The High Court was therefore not justified in holding the insurer liable. So this sums up my argument. And Lordship, as regard, Lordship, I had also that come out on the first day your Lordship had taken on. The ground that it was taken for repairs. It does not seem likely because that place where accident Kadamguri does not lie on the it does not lie on the route, if I may say so. My land friend will correct me. I had obtained the map from the real Lordship downloaded. It does not lie on the route. So what was it doing if it was being taken for repairs also? Credibility of that ground. It does not, it's occurred in an interior place. It was used without permit. And not even for repairs as it is claimed. Lordship, I may pass on a copy of that.
Yeah, Mr. Islam, we will hear you after the break. At 2 o'clock.
All right.
So, how this map will help you? How this map will help you?
Not because he has taken a ground on the first day. It was the Lordship had asked it, whether it was being taken actually for a year, whether it was lying on the road. Not as per this map, I don't think that particular place where accident occurred, Kadamguri, lies on the route from here. It could not have been a place because such a big vehicle, no ordinary workshop can undertake any work here. Big vehicle, dumper, 10-wheeler. It has to go to the authorized showroom. I do not think any authorized showroom probably.
Not there.
It is on the way. It looks very like it looks like a.
It is on the way. It was.
But is there any authorized? It does not even fall under highway. That is, I try to do some work.
Okay.
Item
Yes, Mr.
20, Your
Islam.
Lordship. Yeah, 20, Your Lordship. I have filed this appeal, Your Lordship. My case is that, Your Lordship, it should be modified because the owner is not liable because there is a valid insurance policy and the vehicle was purchased on, Your Lordship, and purchased 29/1/19. And accident took place on 30/1/19, next day. On the very next day, it was accident took place. It was purchased a new vehicle. 29/1/19, it was purchased. An accident took place on 30/1/2019. On the very next day, it was on the way to Your Lordship garage of Howley, Your Lordship, that accident took place, Your Lordship, for fitting some accessory charge. It is judgment of it is mentioned. It is on the way
No,
to.
the question is whether your vehicle has a permit on that
No,
day or
permit
not.
was not there. It is admitted permit was not there. It
Then?
is on the very next day, Your Lordship, and the vehicle was an empty vehicle.
No, from who is that permission? That permit is required.
Permit is to ply, Your Lordship, but it is a empty vehicle on next day, Your Lordship. It is not carrying any passenger or goods, Your Lordship.
It is on the way to fitting some accessories on next
no.
of purchase.
Whether permit is required to fly such a big vehicle.
Yeah, your lordship, if it is carry your passenger or your goods, then it
No,
is
no,
okay.
the question of passenger does not arise. Carrying of passenger does not arise. So admittedly on that day, your vehicle has no permit.
Not permitted, because
No
on the new vehicle, it is your lordship, no, it is required time to obtain permit because we have to apply to the transport department as per section 18.
Then
So that
why you have taken out the vehicle?
I would for your for fitting some for repairing, like repairing for accessories, some parts your lordship, for fitting. On the next day, your lordship, the new vehicle, we have to attach some parts your lordship, dalai, I think lights and some other things. And there is some exception also is there, but it is not required. But your lordship, the white sense
What exceptions is
is
required?
66 or 3 your lordship, that vehicle, some of the vehicle permit is not required.
Page number?
Your lordship necessary, section 66 of the act.
Section
66 necessity of permit is there, subclause 1. Subclause was is necessity of permit is required, your lordship, and subclause 3, your lordship. The provision of subsection 3 shall not apply. In some vehicle, there is no case. If the government vehicle and is the fire brigade or ambulance, and it come to your lordship page P, next page, your lordship, subclause P, to P, to any transport vehicle while proceeding empty to any place for purpose of repair. And in wide sense, your lordship, fitting accessory, it is come under repairing, your lordship. It might interpret it as broadly it's because there is shortage some new vehicle that we have. It is difficult, then we have go to the. Because vehicle as empty, it is admitted, new vehicle on next day it is purchased, and it was proceeded to a garage of Howley Town.
No,
Yeah.
Mr.
Lots.
Islam, to take this plea, you have to establish that you have taken the vehicle for the purpose of repair.
Yes.
Admittedly, the vehicle is a new vehicle,
New vehicle, next day.
where the question of repairing is repairing arises.
We knew. If your lordship considers what description, because there are some parts, even new vehicle also, you have to assess some, fitting some accessories required.
No, repairing and
No,
fixing,
exact meaning is
and-
not there. Your lordship, exact meaning is repairing is damage or something, then it
Yes.
replace, then it's repair. But if you, for running the vehicle, you have to add some accessories part is required.
that kind of interpretation may not be available to you.
And your lordship, moreover, the driving license insurance policies, they are valid insurance policy. And if minor expense is not directly involved in this regard, we have liable husband of the tax code. Well, lordship, that minor discrepancies, it is not directly involved.
Pardon?
I have reliable judgment, your paragraph 90. Yes. Page 337, paragraph 80. We have construed determined the scope of section 22, minor basis of license condition, such as want of medical fitness certificate, requirement of about the age of driver, like that, found have been the direct cause of accident, would be treated as minor basis of inconsequential deviation in the matter of use of vehicle. Thus, minor and inconsequential deviation with regard to licensing condition would not constitute sufficient ground to deny the benefit of coverage of insurance to the third party. My vehicle is a third party policy is there, they are minor, this is not directly involved the permit in this.
No, this is in respect of what?
In respect of, in fact, it is a driving license,
In respect of permit.
Not-
How
not.
is the decision will help you?
It is minor because sir, minor inconsequential deviation, it is not directly, permit is not directly
That
involved
is
with,
in respect of license, not in
it is not,
respect
it is driving license. It is in respect license.
but it's a minor basis of condition we consider because it is not, permit is not directly involved here. And moreover, this vehicle is empty vehicle here, not carrying, if it's carrying passengers or goods by apply for commercial purpose, then it is, I think is something different. And it was, it was, your lordship, it was moved to the your lordship workshop with the garage that they have also issued certificate. It is not exhibited. It was moving to workshop at only for necessary assessment.
Whether you have examined this person before. the
Not
terminal?
not examined.
Then
It's not that, but it is mentioned in the judgment, not examined that person.
Then?
But admittedly, that is there, because it was not with empty vehicle is there, yeah, license, it is a new vehicle next day. Your details yesterday took place. And minor discrepancy, it is not directly involved in the end. So I have to try to find any judgment right to permit, it is not found.
they will make further research if there is any decision of Supreme Court in respect of deviation in respect of permit. This is in respect of license. This will
Driving
not help
license.
you.
Driving license.
Will you fix it next week?
Lot.
Next Thursday?
Lot.
Or sir, Argusami learned counsel for the appellate in MSc appeal number 332 of 2021. Also heard Mr. S. Islam, learned counsel for the appellate in MSc case number 285 of 2020. And also heard Mr. M. A. Ahmed, learned counsel for the respondent number 1. Argument concluded. Place the matter on next Thursday for production of judgment by Mr. Islam before this court. Please take on.
On 13 November.
Obliged.
Item fixed at 2 p.m. Item number 2 for admission.
My lord, in this matter, my part was concluded earlier. There's a case where a punishment was imposed upon a bank employee, and on the last occasion, the lordship directed the bank to produce the record and for their argument. Lordship, I have been asked to produce the vouchers.
Yes.
That is at page number 38. Entire record, not the vouchers.
Page number?
Page number 38, your lordship.
Yes.
We have received the vouchers, your lordship. That is the date of the actual vouchers, your lordship put to verify that whether the original is available with us or not. Thank you. My lord, in fact, your lordship wanted the entire record of the domestic inquiry, departmental procedure. Now, whatever I am getting it from the original vouchers, these perhaps I do not know. There is no marking of exhibit by the inquiry officer in the original vouchers. Your lordship, I have to call the officer with the record, your lordship. So he has to state that whether the exhibit has been marked or not, because the exhibit mark is there, your lordship. And it has been in the inquiry proceeding also, it has been written, your lordship.
No, you have been asked to produce the file.
File of the departmental proceeding. Unfortunately, your lordship, the file that they have sent is the another file, your lordship. It's not the file that has been pertains to this document, your lordship. They have sent the.
No, not the documents, but the departmental proceeding initiated against the petitioner.
Your lordship,
File.
2 days maybe give us, and bring the entire file. Your
My lord, last occasion, my friend made a submission before lordship that he had received the record, but
I
he
was not
wanted
able
to
verify it, sir.
go through it. Now he's making a different submission. My lord, what's the prevalent practice? There is this, employees are guided by a bipartite settlement which prescribes the procedures. So everything, I'm just sharing a copy of the bipartite proceeding, settlement. If your lordship comes to page 13, it says in cases page number 30 is the bipartite settlement between the bank and the workers union governing all nationalized banks. So this is the proceeding initiated under this bipartite settlement, which was effected on 2002. If a lordship comes to page 13, I have marked it, clause number 10, in all cases in which action under clause 4, 6 and 8 may be taken, the proceeding held shall be entered in a book kept specially for the purpose, in which the date on which the proceedings are held, the name of the employee proceeded against, the charges or charges, the evidence on which they are based, the explanation. So they have to maintain a record. Lordship is well aware that a departmental proceeding where an inquiry is held is a type of quasi judicial proceeding where order sheets are maintained, the documents, the witnesses, the charges, everything is kept. So if the documents relied by the employer, management or the bank in respect of the charges, those documents are marked as exhibits. So if that is marked as exhibit, definitely the original bank vouchers will be marked as exhibit. But they have marked something and the original, if I'm not wrong, I'm just hurriedly gone through the original voucher, lordship will see these original vouchers which are before a lordship now doesn't contain any exhibit marking.
No, your lordship, this mark, both the
Kintu,
MEX1 and MEX2 is marked. It's not that it is not marked. And thereafter the serial number has been put also. And each exhibit is been matched with the list that has been given at the page number 8. And besides that, your lordship.
No, but where is the signature of the
inquiry officer.
inquiry officer? Where is the date?
Let me know. But your lordship, these are the documents which we are prepared, your lordship. This is the list, your lordship. It completely start from inquiry proceeding register, then thereafter management exhibit 1 to 5. And that has been also in the cross examinations, it has been accepted. And there is nothing like a situation that
No,
has
no,
been.
merely because he admitted in cross examination, you cannot succeed in the proceeding.
Basically, my lord,
The photocopy of the exhibit number 2, MEX2 is also there, your lordship, that I have produced before your lordship. And the first page that just I have given the document.
This is being done in so casual manner. Without any signature, without any date.
My lord, if my understanding is correct, inquiry proceeding has to be maintained in a record, and the
Yes,
entire
your
record,
lordship,
my friend is producing something, exhibits, the record, it should contain the proceeding also.
Number
I have
of
given,
documents has been mentioned there. That is there.
I have given the copy of the inquiry proceeding on the last date, which was furnished to me, but the entire record, which your lordship intended to have a look at, it should, my lord, in the name of producing record, basically, my lord, what is the allegation? Allegation, if I'm not wrong, allegation is I have received money from the customers on certain dates and I have not deposited the money. And I have deposited in a subsequent date. Now, my lord, 3 things to my understanding is required, my lord. Because your lordship is aware, whenever there is a requirement of cash deposit, the customer visits the bank with a voucher and a scroll number is given on the top of the voucher. That scroll number is maintained in a scroll register, and that scroll register is then tallied with the cash received every day. Now, in none of the vouchers there is any scroll marking. Now, my lord, number 2, even assuming for the time being that I have received the money, but where is the evidence that it was not deposited on that date? To prove that after receiving the money was not deposited in the account, definitely the inquiry proceeding ought to have seen the account statement of those particular accounts. Now, if account 100 rupees is received in account number X and the allegation is you have not deposited 100 rupees on such and such after receiving it in the account number X, then to complete the chain, that account statement of account number X is required for that
No,
particular.
Mr.
Admission is
Chakraborty,
there, Your Lordship.
let them produce the file. Thereafter, we'll see the entire file, whether it is there or not.
It is not there, my lord. Because I have given I have produced your lordship the minutes of the inquiry proceeding. It is there on the last date. And in that inquiry proceeding, nothing is reflected as to whether the account statement is produced.
No, if it is not there in the file,
Hmm.
then definitely the benefit will go to the
Well,
petitioner.
What I am submitting, my lord, he was supposed to bring the entire file, and on the last day, the submission was made that he received the file, but he could not go through it. And today, some documents are placed, but not the entire file.
I was not able to, that I have communicated to them, but they have sent me only this document.
Because
And the
if I am
registration
not
they have
wrong,
sent, I
this
think
matter
it
was
is an
heard on
inquiry
5th of September, and we are on 6th of November, 2 months.
If they are so casual, then let them have the consideration.
My lord.
I'm very sorry, Your Lordship, just one time.
So then on what basis you have submitted on that day that you have received the file?
Yes, Your Lordship, I have received, Your Lordship. But they have given me the register. Well, I think that it is an inquiry register, but it is an attendance register they have sent to me. Two books has been sent to me, that is an attendance register, Your Lordship. And they have
Attendance
given a
register,
voucher and the-
attendance register is not the part of the inquiry
Not
proceeding.
registered.
It is not there in the inquiry proceeding.
Okay. Heard Mr. Chakraborty, learned counsel to the petitioner, Sir Sarda. Counsel, I think counsel for the response. For Mr. Sarda submits that though he has received the file from the respondent authorities, the same is not related to the departmental proceeding drawn up against the petitioner. Accordingly, Mr. Sarda submits that it is granted from time to purchase the entire file relating to the departmental proceeding initiated against the petitioner. Where is allowed list of matter.
13th,
That was 2020, Thursday.
20, my lord, 2021, I will not be in station. Can it be on 13th? Because
Yes, Asal,
Okay.
Even the 13th, no, Your Lordship, I am in Manipur, Your Lordship, on that day, Your Lordship. Sorry, maybe given Your Lordship, 13. 11, I am in.
13th is next
Maybe
Thursday.
given.
So, these vouchers you can take back.
Yes, Your Lord.
क्या दिया हमको ना सोचा दो
Item for hearing,
खोल देंगे तो चलेंगे.
नहीं
item number 22.
You see, this matter was kept as ordered
Lordship.
on 5/11/2023.
Yeah.
Now more than 2 years elapsed.
Lordship.
I have not remembered anything now.
Definitely, Lordship will not remember it.
What to do?
Lordship may, if Lordship, I may pray, Lordship may release the matter if Lordship. Let it come before the regular criminal benches.
Heard, Mr.
Jadala.
Learned counsel for the appellant and Ms. Dasko respondent number
For the state.
For the state,
for the state respondent and Mr.
yeah, for informant. Respond
learned
to.
counsel for the comment. Okay. Good. Good. Third. Emma. It appears that this matter was kept as parted by the order dated 5/11/2023. And since then, more than 2 years elapsed. 2 years elapsed. And the hearing could not be completed due to the adjournments taken by either of the parties. Accordingly, this matter stands released from the parted. Recess shall list the matter before regular events.
Item number 24.
Wait, this is lordship. Look, this matter was initially instituted by the private respondent, claiming seniority over the petitioner. This honorable court, my lord, by an interim order in the earlier round of litigation, directed the my lord, authority to determine the seniority between the two, the petitioner as well as the private respondent here in my lord. And by the impugned order at page 40, they have decided the seniority between the private respondent as well as the petitioner. But hereby, my lord, I have no grievance against the private respondent as regards the seniority. But only thing, my lord, I have been reverted back to the original post of LDA. That perhaps, my lord, is not good because the petitioner was upgraded initially. Lordship, kindly peruse the impugned order at page 40. Page 40, my lord. May I read, my lord?
Okay.
May I read, my lord?
Attorney, you have been directed to file an affidavit.
That affidavit, in fact, I is ready, my lord. I could not file because I've sent it for waiting. It's not returned back.
In the meantime, the petitioner has also been retired from his service.
Already retired.
My lord, on 30th of October, my lord, this year. He has retired as a teacher, my lord. At this stage, my lord, he may not be reverted back to his original post, my lord. Yes.
Now, whether the affidavit has any relevance, since the petitioner has already retired.
But thing is that, my lord, his application was reverse the rules. That is why, my lord, this order was passed by degrading him to his original post to the post of LDA.
In this regard, my lord, from the impugned order itself, I will make a small submission. The private respondent here in my lord, he was also initially appointed as a ad hoc teacher. Rule does not contemplate any provision for regularization. Rule does not permit. but his service has been regularized. His service has been regularized. He has been granted the seniority from his date of regularization. But in my case, the authority is saying that my upgradation was the rule, so I cannot be regularized. This is the two different stand in as regards to different persons now. Because in the impugn order itself, it says the private respondent was initially appointed as ad hoc teacher. His service was subsequently regularized by the authority. But in my case, they cannot regularize my service. This perhaps is, my lord, is not equality before two.
All right, but without his affidavit, can we?
Yes, my lord, that affidavit may be required, my lord. Because
Next week I can file, my lord, because there are some, I require some clarification, that's why they sent it back to me, my lord. So, my lord may take it on last week of November, my lord.
Last week,
Yes, my lord.
pardon me, sir, I circular or the. Sir, respondent. And Madam Yupa? Respondent number 4. Mr. Katuner submits that though he was directed to file an affidavit by the order dated 28/8/2025, he could not file the same, as the same was returned to him by the respondent authorities for
For some
clarification.
clarification.
For clarification. Then, after the clarification, he has returned the, no, he has he has sent the file again to the respondent authority. Then we'll be filing the affidavit within a period of 1 week from today and send it to the matter. The last week of November.
On 25th, my lord, we fix it on 25th, my lord. 25th. So I can, then I can file it before that, my lord, if he wants to file a reply, my lord. 25th, my lord, I have lots of methods, my lord. On 27, my lord. 27? On 27.
Item number 32.
Obliged, my lord.
Meet please, Lord. My lord has heard this, we commence the hearing on this matter on this issue, the specific performance of suit, which is filed by the plaintiff and decree to the extent of giving him the relief of the flat which number one, the plaintiff number one had sought for, and secondly, in the alternative decree that was relief that was paid for in respect of compensation. I will just, because to refresh myself as well, because it was heard a long time back. If we had, my lord may take up RFA 116 of 2017.
116
of 2017.
Yes.
Which is filed, Megamala Estates and Services versus Dr. Kishore Kumar Das. This is in respect of title suit 86 of 2010. And the judgment and decree passed therein dated 17 July 2017. So, my lord, the issue is that this is basically a dispute between the developer, the appellant herein is the developer promoter, and the two persons, the husband and the wife. The wife, who is the plaintiff and a respondent in the other RFA, my lord, 119 of 2017. So the wife therein had purchased a flat. Of measurement 1,375 square foot in the first floor of the apartment complex, which was a 3-bedroom flat. Thereafter, as I'll just give the brief synopsis. the husband has also averred that he purchased the ground floor. The wife purchases the first floor, 1375 square feet, a 3-bedroom flat. The husband purchases a ground floor space of around 1000 square feet. In averring that, there is also a consensus between the developer and the parties that 400 square feet of frontage in the ground floor would be allotted. The purpose behind there being the entire space would become a doctor's chamber come clinic, because both of these purchasers are doctors. They say this is going to be a doctor's clinic come chamber. That is the intent behind the purchase, so that this entire the frontage can be converted into a front area reception desk. Then the flat as well as the ground floor can be converted into doctor's chambers, patient's waiting room, so and so forth. So that is the basic plea that has been set up. Now, when we come to the plaint that is at page 7, title suit 86 of 2010. For the sake of convenience, we are going to take up the TS 86 of 2010, wherein the prayer is at page 20. I'm sorry, madam, that is at page 36. It starts at 36. My lord, 35, page 35, the first prayer. We have to go suit by suit because, my lord, even though these are related party transactions, different reliefs have been sought for, and different these are different purchases, different sale agreements which have been sought to be enforced. Now, decree of declaration in favor of plaintiff against the defendants, that the defendants are bound by the registered deed of agreement bearing 8705 of 2007, dated 6/7/2007. Therefore, in this case, my lord, we are faced with the registered deed of agreement 8705 of 07. Here it is annexed here. I will read that as well. Between the plaintiff and the defendant number 1, the plaintiff herein being the husband and the scheduled property in question being the 1000 square feet of the ground floor area. That, my lord, we will segregate from the overall flat. A decree of declaration in favor of plaintiff against the defendants for specific performance of the registered deed of agreement so-and-so, dated so-and-so, in respect to the area more specifically described in Schedule 8 of the plan. The plaintiff thereby directing the defendant numbers 1 and 2 to obtain the permission from Guwahati Metropolitan Development Authority for conversion of the Schedule A area into a semi-finished area, and thereafter execute a registered deed of sale in favor of the plaintiff in respect of Schedule A area as per so-and-so agreement dated so-and-so within the time specified by this honorable court, failing which deed of sale be executed and registered according to provisions of Order 21 Rule 34 of the code. Third relief sought for is at next page, page 37. Decree of permanent injunction in favor of plaintiffs, defendants, restraining the defendants and so and so from allotting the Schedule A area to any person or persons in any manner whatsoever. And thereafter, the alternative reliefs are, my lord, which is what came out. Relief 5, prayer 5, the plaintiff placed for decree of recovery of 40,30,124 from the defendants on account of recovery of the principal amount, along with interest as well as for special damages stated in paragraphs 28, 29, and 30 of the instant plaint. Decree in favor of the plaintiff for general damages as deemed fit and proper and costs and other. So, my lord, the Schedule A is given at page 38. As I've reiterated before, lordship, this is the ground floor space of 1000 square feet under the flat number 101/A1. This flat would be the scheduled property in the other suit and other connected appeal. So, situated in Ganeshgiri Jatiya, but selling a plot of land measuring so and so in the district of Kamrup Assam and bounded by so and so. Well, these are not in dispute. What is the dispute therein is the agreement. What does the agreement and what is the contract between the parties which is sought to be specifically enforced? For that reason, my lord, may come to the deed of agreement bearing 8705/2007 dated 6 July 2007, page 67 of the appeal. Page 67.
Okay.
This is an agreement 8705. This is the agreement in question. This deed of agreement made on 6th day of July 2007 between the appellants here, Meghmala Estates and Services Private Limited, represented by its managing director so and so, and Dr. Kishore Kumar Das. Now, my lord, we come to 69, page 69, which is the second paragraph therein, internal pagination 2, second paragraph therein. And whereas the second party applied to the first party for allotment of 1,000 square feet in the ground floor in the complex known as Meghmalla Hillview situated at Ganeshgiri, Jatiya, Guwahati, more specifically described in Schedule C. So, my lord, that is 1,000 square feet is ground floor space. The agreement is clear on that point. Third paragraph, second party purchase agreed to purchase an ownership basis at the Jatiya having 1,000 square feet of ground floor in the complex described above for a consideration of 9,30,000. The consideration is 9,30,000 payable. Against cost of floor, roof, proportionate share of the land and construction charges including raw materials. Now, my lord, this is the construction for the floor, roof, proportionate share of the land and construction charges, 9,30,000. Next page, my lord, may come to terms and conditions for the allotment of an apartment of Meghmalla. Clause 1, which is relevant for the reason that although it is a generic clause, that they have applied for an allotment of apartment with full knowledge and subject to all the laws, notifications and rules applicable to this area in general and group housing project in particular, which have been explained by the company and understood by him, her, them. This will come in later. Clause 3. The intending allottee has seen and accepted the plans, design, specifications as set out in the brochure and agrees that the company may make such variations, alterations, modifications therein as it may in its sole discretion deemed fit and proper. And as may be done by any competent authority, and the intending allottees hereby gives his consent to such variations, additions, alterations, and modifications. The intending allottees has also seen the specifications and information as to the material to be used, which are also tentative, and the company may make such variation and modifications therein, as it may seem fit in its discretion, seem fit and proper. The purport behind this clause 3 is that the allottee has seen and accepted the plan, design, specifications as set out in the brochure, and on that basis has applied for that particular 1,000 square feet ground floor space, my lord. Clause 4. The last portion of clause, this is also again reserves the right of the company to make effect addition suitable and necessary alterations, which may involve all or any of the following changes: change in positions of the apartment, change in the number of the apartment, or change in dimension or change in area. To implement any or all of the above changes, supplementary agreements, if necessary, will be executed. If there is any increase, decrease in the areas, the rate per square feet, meter, and other changes will be applicable to the change area at the same rate at which the apartment was booked. If for any reason the company is not in a position to allot the property applied for, the company shall refund the amount deposit with simple interest at the rate of 10% per annum. So clause 4 states that the company can modify the area allotted to the particular allottee. The reason purport behind my reading this clause is again simple, because one of the contentions which will be placed before lordship is that when the ground floor space could no longer be provided as per their desire. The ground floor space contract was for providing a ground floor space. They desired a semi-constructed ground floor space with GMDA permission, municipal permission to carry out the clinic operations. When the permission could not be obtained, the term of the condition could not be fulfilled, for reason being the operative law standing in the way of performance. But thereafter, the plaintiff sought an additional 2-bedroom apartment in lieu thereof. Now their plan changed. The ground floor apartment could not be made into a block, finished block. It became a ground space. So they sought another apartment on the first floor, contiguous apartment. Now the contiguous apartment, there was no contiguous apartment available at that time. There was no apartments had gone off. So therefore, they pleaded that we had breached the promise that we had made to them. But herein the clause is particularly clear that company can effect any changes or alterations in the positions of the apartment, number of apartment, dimension, change its area. And to implement all the changes, supplementary agreements could be executed. Now I ask myself, my lord, that assuming for the sake of it, I have purchased an apartment and the builder, acting in a high-handed and most arbitrary fashion, has changed the dimensions of the apartment. That may not be permissible in law. I have a right as a consumer, as a purchaser, to get what I have paid for. Therefore, an action may lie against such an action of the developer. A suit may lie. Now, when there is a change in another apartment, another scheduled property, which is not even the subject matter of agreement between the plaintiff and the defendants, which is not even in the subject agreement, that the developer has the fullest right extent possible to make any changes or alterations, whether it is contiguous to the earlier apartment, whether there is a change in the position, dimensions have changed. And that is the only reason why I'm pointing this out early, because I'll return back to it later on. At clause 6, the intending allottee agrees that he, she, they shall pay the price of the apartment and other changes on the basis of the super area, covered area of his apartment, pro share of the common areas, and converted cost of services like cost of lift where applicable of the building. So, my lord, that 9,30,000, again, we have said construction of the floor, they specified what are the costs which covered in 9,30,000. There are other amenities which also have to be paid by an allottee. This is important because they are contending that 33 lakhs was the overall package deal agreed upon between the developer and both the plaintiffs together. Ground floor, first floor space with a semi-enclosed built up property, and towards that 30 lakhs was paid. Now again, the first generic question which I would pose before myself is that when, assuming that a 33 lakhs was the package deal agreed upon and 30 lakhs was paid, and till date 3 lakhs has not yet been paid, where is the readiness and willingness to profit? That is on the law point of the matter. That till now, even if I accept the reverments at face value, they have not paid what they agreed to pay in advance as per their own averments and their own letters, correspondence. That even if I agree that I have to provide the ground floor built up as well as first floor, the total amount of consideration agreed upon, specifically mentioned by the plaintiffs as being 33 lakhs for the entire package, has not yet been paid in full, let alone in advance, as on date.
33 lakhs?
33 lakhs. Total, the flat is, this is 9,30,000. There was another, the first floor. In the other suit, the flat is valued at around 12 lakh 30,000, I believe. So I am only assuming there.
What was the advance amount?
The advance amount, my lord, this has been paid from time to time. There is no advance amount paid. There are installments. That the schedule of payments is enclosed here. It is in their suit. They have paid from time to time in the plaint. I will just mention, yes, my lord. From 23 June 2006 to
Where
Five-
it is mentioned?
page 16. This is the plaint. Page 16.
16?
16. There is a table. Lord.
Okay.
This is the schedule of payments according to them.
No, this schedule is
This is-
prescribed in the agreement.
No, my lord. This is their statement that we have paid so much, this much amount every few months, of 40,000, or 1 lakh, or 3 lakh, by either the plaintiff, present plaintiff, or his wife, towards the entire what they are claiming to be a package deal of the ground floor as well as the first floor.
Mm.
Totally amounting to, they have said 30 lakhs.
Mm.
So as on date of filing the plaint, they have averred that they are paying an amount of 30 lakhs out of 33 lakhs. And in their own averment, that there is a letter also issued which they are relying upon. The builder agreed that, all right, you take the first floor and the ground floor, but you pay it in advance. That also I'll be referring to as page 106, if I may point out. My lord may come to page 106. This is their letter. Marked as exhibit 28, dated 19th of
Yes.
February 2009.
Hmm.
I'll just read the first 3 paragraphs because that is relevant. In fact, I'll read from the 3rd paragraph.
Hmm.
At that time, the project was in initial stage and NOC for construction of the GFS, this is ground floor space, had not yet been received by the company. After discussing with other directors of the company, he informed us on 20 June 2006, the company will provide the ground floor space if they get a NOC and a 3-bedroom flat. If the LOC for the ground floor space is not possible, then the company will provide a 2-bedroom flat on the first floor contiguous with the 3-bedroom flat allotted to my wife. Price was fixed at 33 lakhs, provided we made advance payment. We readily agreed and paid rupees 4 lakhs on so-and-so and 6 months. Another 4 lakhs were paid on 12/2/2007. So they did not pay in advance, they paid in tranches. So even if I assume, number one, 33 lakhs is what they are saying is the total consideration, they have paid 30. There is no, till date, it has not been paid, let alone paid in advance. Now again, the suit valuation itself tells us, as on 40 lakh valuation, that the amount of 33 lakhs that they paid is not actually the amount towards the sale consideration of the first floor space and the ground floor space. This plea I have taken in my written statement. This plea I have taken in my written statement at page, my written statement is at page 41 as well. 41. Page 43 would be the relevant averment. Page 43. The specific payments which I have admitted. Paragraph 6, it is submitted the respondent received payment of cost of a 3-bedroom flat from Dr. Madhumita Das Mazumdar, rupees 7,45,762 only and 1,54,238 to a Society Corpus Fund, GMC Holding, External Electrification, etc. Total amounting to 9 lakh. So my lord will again note, I refer back, 9 lakh 30,000 is a consideration, although that will be coming around to the second part. Amount received from Dr. Kishore Kumar Das towards the cost of the 1,000 square foot space, rupees 647,700, 52,300, total 7 lakhs. So 9 lakh 30,000 is the price of the flat, not including electrification, GMC Holdings, Society Corpus. These are not included. It is learned from site engineers that the plaintiff has incurred cash expenditure around 14 lakhs for the internal construction of the 3-bedroom flat directly by the plaintiff within the knowledge of site engineers working at site. The company has received only 16 lakh in total from the plaintiff and his wife, as stated herein above. So our categorical averment is that you have made alterations, modifications in the flat to make it into a possibly a doctor's clinic enable. These interior modifications are not part of the contract of that agreement 8705 of 2007. Therefore, by merely including the expenses made towards interior modifications in the towards the final consideration of flat, it cannot be said that they have paid even 30 lakhs at all as on date. These are their expenses, their choice. They have coordinated with the site engineers who are admittedly employees of my company. They have said, we want like this, we want the interiors in our manner. And it is their prerogative. But it cannot be their prerogative to adjust the amount paid for their own modifications towards the sale price of the flat. Now, page 44 in paragraph 12. the other issue which is in context is the ground floor space, which is actually the scheduled property. Are they content? The question here in before Lordship is, are they content with that ground floor space? Because if they were content with the ground floor space as they had agreed to buy, then it is, even as on date, it is available for handing over a possession. But the issue arose because they were not desirous of the ground floor space on an as-is basis. They desired it to be a built-up area within the enclosed area, properly for their own purposes. Now, I have averred in the written statement, they have personally approached the concerned authority for allowing permission of 1,000 square feet. It was learned that there is no provision in the revised building bylaw to give necessary permission other than parking space and open spaces provided in the bylaw. So therefore, the municipal bylaws do not permit construction in the ground floor space beneath an apartment complex for anything other than parking and open space. Hence, the respondents did not approach officially to the concerned authority for obtaining no objection certificate to use the 1,000 square feet space for clinic purposes other than parking area. So there another contention was that we had not specifically applied before the municipal authority for permission to construct in the ground floor space. Our reply was that it is an admitted fact in law. When the municipal laws do not permit construction in the ground floor space, there is no question of applying. And once the builder is made aware that the law does not permit consideration of such an application, even making an application is redundant. That is what we averred in paragraph 12. It is an admitted fact that the plaintiff was well aware of the fact that no objection certificate cannot be obtained to utilize the space of 1,000 square feet for any purpose other than using the same as parking space. Hence, the plaintiff agreed to take a 2-bedroom flat, but not contiguous to the 3-bedroom flat, as there is no such provision in the planning having contiguous 2-bedroom flat with the 3-bedroom flat. So the plan also did not envisage a contiguous flat on the first floor, 2-bedroom or 3-bedroom. We again averred that we were willing, if he was not satisfied with the ground floor, with extra payment, the plaintiff could have taken a first floor 2-bedroom flat, but not contiguous, because the plans did not allow for such a thing and there was no planning for a contiguous flat area. Further, the payment schedule shown in the plaint is not in agreement with the account maintained by respondents. It is submitted that whatever excess amounts shown to have been paid to the respondents were expended directly by plaintiff towards interior modification of the flat with the knowledge of the site engineers for completion of the 3-bedroom flat number 101. Respondents deny receipt of 12 lakh from the plaintiff and 18 lakhs from the plaintiff's wife. They have received only 7 lakhs from the plaintiff and 9 lakhs from the plaintiff's wife. So therefore, my lord, the payment is also in dispute, that it is not there. This part of it has been extended for other purposes, modification. We are taking shelter under the cover of
In the agreement, there is no provision for advance payment.
There is no provision in the agreement, my lord.
Yeah.
In the agreement, that is what, my lord, that in the agreement, there is, you have to be paid in advance. I am saying that, my lord, if I accept that letter, which they have themselves written of 15 February 2009, that the entire package deal is 33 lakhs. Leaving aside that it has been modified, that amount consideration in the agreement has been modified subsequently by oral negotiations between the parties. Even if I accept that part, that the next part which follows is that, as per their own letter, is that it has to be an advance payment. They cannot pick and choose the particular conditions which are convenient to them and leave out other conditions which are inconvenient to them. And modification of the original.
Just few minutes back, you have submitted that they have not paid the advance money.
Yes.
And there is no readiness and willingness on
Willingness.
their part to perform their part of contract. So if it is not there in the agreement itself, then how can you?
That is what, my lord, my first basic point is, it is not there in the agreement that you have to pay 9,30,000. One plaintiff will pay 9,30,000 for ground floor space, 1,000 square feet, shorn of all embellishments, no furnishing, not a question of built up area, because it does not envisage. Now, even assuming that I am wrong and that their subsequent negotiations have led to their impression being that there is a package deal offered to them of 33 lakhs. I assume that I am wrong. They are correct. 33 lakhs is a package deal. Even then, to implement that modification, it must also be implemented in total. 33 lakhs has to be paid in advance. As on date, even as on now, as we are hearing this, because only 30 lakhs as per their averment they have paid. There is no whisper or mention as to when they are ready and willing to pay the balance 3 lakhs. Even their own case is beset with the same loopholes, which a suit for specific performance is afflicted by, is vitiated by. So therefore, my case is clear. If I were to go in a very simple manner, that there is an agreement, it specifies you get a ground floor space of 1,000 square feet. The agreement does not talk about getting permissions, getting building this, that, or furnishings, fittings for a doctor's chamber. That is subsequent developments which they have tried to bring in by way of letters and correspondence. That there is a negotiation. I agree that I will try to obtain permission for them. I say that fine, I will try. In fact, it is an admitted fact that I have tried to approach the municipal authority. Is this possible? That is the construction at ground floor space possible? I have been rebutted back firmly that law does not permit. It's a parking space or an open space below the apartment floor. On top of that, being used for commercial purposes, chambers, doctor's chamber for commercial purposes, law is not permitting that. So therefore, even if now the question is not only can I not fulfill that purported promise that I have made to them, they also have to accept that the law does not permit that. Tomorrow parties may negotiate with each other and say that for extra consideration, can the space be built up in the ground floor? The answer is no, categorical. That is what we have tried to explain, that there cannot be an assurance and there cannot be an enforcement of an assurance which is dehors the legal provision. They are seeking enforcement that in case you have to give me the ground floor space with built up as per original or negotiation and assurances. Now, all negotiations and assurances fail if the law does not permit it. What remains? Thereafter, we have to fall back on the agreement itself. If the agreement is categorical that when there is a failure, as I've read it out before, Lordship, refund of the amount with simple interest, amount paid. So our contention is, what is the amount being paid? 7 lakhs, which we have received with simple interest. Obviously, we cannot run away from that responsibility as well. If you have received an amount and the contract says that you have to refund the amount, once the contract becomes impossible to perform, you have to refund an amount at 10% simple interest, then I have to do so. I cannot run away from that. My contention is that there are other reliefs that they are seeking, that we have paid 30 lakhs. Part has been paid to the engineers. Those are not things that fall within the ambit of the sale consideration. Those are not things that are capable of being enforced. In order to be part of the contract, it has to be shown that these were modifications introduced with the express intention of modifying the contract.
Now, Mr. Porua, you were ready to return the sum you have received.
That is what
With simple interest.
that is what the court ordered. But
That is the
with
court's order.
that is a court order with there was a dispute as to the sum. That is why we preferred the appeal. That there was a dispute as to the sum. In the first instance, first plaintiff, the plaintiff's wife, we had averred that the flat is ready. It is even ready to be taken over possession at any date. There is no encumbrance thereon. And in fact, it is wasting away because nobody is occupying the flat. Even now, they have not shown any inclination to occupy the flat. So that part aspect on the other suit, that is ready. Second aspect is the ground floor space, which they paid the 7 lakhs. They did get the 7 lakhs with their interest as per the contract. And I have deposited a part amount of the awarded amount. I have deposited already before this honorable court with necessary adjustments. If there's anything I have to pay, I will pay. I cannot shy away from that. If my lord made.
No, there's much more to this, my lord. My lord, in fact, we've therefore filed a cross objection. My lord, just to sum it up, basically there was a promise that we will give you 2 apartments. One in the ground floor, one in the first floor. They took money. We've been paying. At the end of the tenure, they say, no, sorry, we can't give you the flat in the ground floor because GMDA bylaws do not permit us to construct. So they give us an option that in the instead of a flat, you take that open space. What will I do with an open space there? Now, the argument regarding specific performance, perhaps my friend may not press that too much because we know there can be no specific performance today. But the question is, if it is impossibility of the contract and the impossibility was known to them, why did they take that money? And if they've done
No, whether it was earlier known to them.
earlier known, that's the question, and that has come out in the cross-examination. That they knew, they approached much prior to the agreement and they knew that that was illegal. Notwithstanding that, they kept on taking money, and at the end of the day, they said that you want this open space, you can have it. And now, my lord, insofar as the ground floor flat is concerned, my lord,
No, whether it was not within your knowledge that ground floor is not permissible for
yes,
such
yes,
construction.
yes.
Now you are blaming the
Yes,
other
yes,
side.
yes. Yes, in fact, there are a lot of correspondences, my lord. I'll show from all of that, there was a continuous assurance that they'll get it done, they'll apply.
No, even though they have given assurance to you,
Right.
was it not your duty to inquire that whether it is permissible under the bylaws of the GMDA?
I can understand where your lordship is coming from. I'll address that point also. Because, my lord, they were in that position of a builder and they knew all of it. The agreement was very clear. It did not say open space at all. It was always referring it to it as the apartment and the flat. And the other issue, perhaps your lordship may also consider that aspect. What was my duty, where was my duty or diligence to inquire whether it was at all possible or not? But there was subsequent letters. The tenor of the letters, your lordship will notice, was initially assuring. Second, it was apologetic. And lastly, they said, we can't help you, take the open space. And that dispute regarding quantum of the amount which I've already paid, my lord, that also I'll try to resolve from the exhibition. Because it had quite a long history of correspondences, which I'll take your lordship for.
So, is there any chance of any amicable setup?
My lord, there is none. In fact, they tried before I was engaged. They tried a couple of times, and now that the stay is operating, the first floor flat is also not with us.
Not?
The first floor flat is, it's like that, it's lying there.
It's lying there because there is a stay operating. So they have not given the first floor flat also. Ground floor, they've not.
Right. Ground floor is not permissible.
Right. So, my lord, ground floor, we are claiming that amount of 12 lakh, which the court said we are entitled to. In the cross objection, we are urging again that we should have been not just the money, there should have been a compensation as well, given this element of profit.
What is the amount of?
That was not granted to us. Therefore, there is the cross objection in the. We had sought close to around 40 lakhs, loss of profit, everything included, but that was not even touched
By the trial court.
by the trial court, which is why there's the cross objection.
So now there is no chance of amicable setup.
Perhaps not, my lord. I am hesitant to say that, my lord, but
No, from the submission of Mr. Korua, it appears that there is some element.
At least the first floor, because it is neither helping me. The stay I cannot sell to anybody. It is lying there, it will rotting away. So if the instruction is obtained, if they're willing to take the first floor.
But I'll just explain. There are two suits, my lord. First floor, if that is the submission today, from 2017, why did they even prefer this appeal? The second appeal, which is by the wife. And after blocking it for nearly 8 years, today they say you are free to take it. We have no objection, my lord. How can that possibly be, my lord? Because second suit, my lord, by the wives, specific performance was granted, my lord. Then they challenged that decree also in the other appeal, which is 119. So from 2017, I've not even been able to get the flat. And today, if they say very conveniently, no, we have no problem, then why did they even file the appeal?
No, you say if there is any chance for compromise.
And
because-
otherwise, I normally, my lord, settlement obviously.
Delay, that is a different thing.
Normally, my lord, I would have said that also. But given this conduct, my lord, they did not. If that is the case, why they could have not appealed from that decree? I could have at least had the flat for since 2016, my lord.
Now they are agreeing.
Now they are agreeing, and now they won't give compensation, my lord. Even otherwise, I was entitled to compensation for the delay. My lord,
Yes,
My lord,
are you agreeable to pay some amount of compensation to them?
my lord, let them ask what they are desiring, at least in respect to the first flat, that if it is renovated or some compensation in respect to the first flat, at least they revert back to me because I was not there earlier.
Mm.
Therefore, I'm only making the submission from the basis of the present day situation.
Mm.
That it's helping no one, that first floor. So if they make a submission, if it does not turn out workable, then we can proceed because, my lord, the issue has crystallized down to a few points. They have alleged fraud, prior knowledge, deliberate misleading. Therefore, they are claiming for not only the specific performance as well as the compensation and damages. That is their part. My prayer is my appeal is simply confined to the contract agreement, and beyond that, that is only a concession which I am trying to make to lessen the complications. If some instruction comes out at this date, that what is their stand?
No, my stand is very clear, my lord. In fact, if that is the submission, it's a fair submission to make, my lord, but it's come very late in the day. So if they have instructions that they are going to compensate me for the delay and for non-delivery of the ground floor, my lord, my friend can have instruction as to how much compensation they're willing to shed, my lord. Your lordship can have it next week.
No, once as submitted by him, it has to come from your side.
Yes.
I have already claimed.
Petition you were requiring.
I have already claimed that in my plea. And I had claimed
No, no.
specific performance.
No,
Malad-
forget about that amount you have claimed in your claim.
Right.
Now,
Now
on the present day context.
present day, perhaps, my lord, we will claim even more because if that is the case, why did they file the appeal in 2017 and sort of delay the delivery again?
No. Now they have realized it that it has not been helping any party. You obtain instruction from your party.
Right.
You appraise this court on next Thursday.
Next Thursday, my lord, I have some difficulty. Can it be 11th or 20th, my lord, whichever is
2020.
20th
20th November. My lord, will post it for hearing because if they
Yes.
I will try to communicate my offer prior to that.
Prior to that.
So if they are agreeable, they can come with the answer on 20th.
Yes.
And then if it doesn't work out, my lord,
But
I'll try to.
I'm only using my good offices so far as possible.
Yes.
It may not work out as well. I cannot also afford the issue.
No, if the amount of compensation the party will be claiming is exorbitant, definitely the other side will
Definitely.
agree.
Definitely. But at the same time, my lord, we
No,
will
that's
claim.
all right. It should be reasonable.
It will be reasonable. That much. Otherwise, we will.
Be exorbitant.
My lord.
Should not be exorbitant.
Right. So, my lord, we'll keep it there for hearing, my lord. I'll exchange the proposal in between, and then if my friend agrees, we can close it. Otherwise, we'll continue with the hearing.
Heard Mr. N. Burrow, Lord Counsel for the appellant. And Mr. Tekra for the respondent. Heard in part, list the matter on 20th.